This hearing is in the matter CFI-054-2018 before His Excellency Justice Ali Madhani and is being held by way of teleconference. Any orders or directions made after or during the course of this hearing will be issued by the Registry in Dubai on His Excellency Justice Ali Madhani's instructions. The claimant is represented by Defendants & Co. Lead counsel is Rupert Reed, QC. The third defendant is represented by Evershed Sutherland International LLP. Lead counsel is Lawrence Page.
My Lords, good morning. I'm sure I join Mr. Page and all counsel present in hoping that your Lordship and the court staff are well. My Lord, there are three matters for hearing today. Your Lordship will have seen the skeleton arguments. Firstly, there is an application made by the claimant for immediate judgment against the first and second defendants. The first defendant, Renish, is the borrower under the trade finance and who hasn't repaid the same trade finance. The second defendant...
Mr. Reed, I had just lost you for the last minute.
Do you have me back?
Could you start again, please? Yeah, I do have you back, yes. Okay,
that's great. As said, there were three matters which the court is hearing today. Yeah. The first is the claimant's application for immediate judgment against the first two defendants. That's D1 Renish, which was the borrower under the trade finance, and D2, which Mr. Mehta, who was the personal guarantor of the trade finance. And we say there is clear contractual liability under, first of all, the facility agreement and also the personal guarantee on which immediate judgment can be given. But we would also ask the court for a finding of fraud. Both the claimant and the third defendants have made allegations of fraud against D1 or D2. The claimant's representations are that the trade finance was obtained by misrepresentations as to legitimate trading, essentially a back-to-back contract between Prime, involving Prime as the supplier, that's the third defendant, and Lanka as the purchaser. That contract, we say, and is clear on the evidence, was a sham. The third defendant also alleges that he is the victim of fraud on the part of the first and second defendant. And one sees that, for example, in Mr. Sadra's affidavit. I don't know if your Lordship has to hand. There are three bundles, essentially. There's a master bundle, which most of the documents are in. There's a small CMC bundle, which we'll deal with occasionally. And there's also an application in the third defendant's bundle in the
Yes, I'm aware of that, yes.
If your Lordship has the V bundle and turns to tab D or page D3.
Mr. Russell, I mean, just to start with, I'm logging in through a video call, but apparently you both, like you and Mr. Page, are appearing through only audio mechanism. So if you just excuse me, I'll drop my camera and I will communicate with you through the audio, just the same way you're appearing. Is that okay with you?
It's okay. If your Lordship would be assisted by us turning on video, then I'm sure Mr. Page and I could do that. But we're in your Lordship's hands.
Well, no, I mean initially I thought you both appearing through video, so that's why I appeared through the video. But since I can't see you both, I said, what's the point? Like,
I've done a number of hearings, and I think the idea has been that if one turns off video, then the audio quality is better. But as I say, we can. Whatever would assist your Lordship, we're in your Lordship's hands.
Well, it could be better. I mean, we've recently done many trials through fully video conference, and it was working very well for 5-6 hours from 5-6 different jurisdictions. We faced no problem at all.
Okay.
But I don't know what the case is. Alia, are you with us, Alia? Alia?
Yes, Judge Ali.
Yes. What is the? I mean, how we prepare for this? Is it for audio or video or audio video, or what is that?
Judge Ali, if you prefer for it to be video, we've asked the counsel to turn on their cameras. However, if you prefer or are happy with it to be teleconference, then we can keep it as is.
Well, I say, but I think the lawyers are prepared not to appear through camera. I can tell. Yeah, I'm fine. I think this time we'll drop the camera and then we continue through the audio system. And oh, yeah, we have Mr. Reed coming up.
Yes, you have.
I see. Yeah, I see. Well, then we come.
Let's proceed with audio. If that's it obviously makes communication easier sometimes.
Yes, okay. I think we'll keep it at the audio level this time. Next time we'll appear on video. So we'll make sure we look nicer on the camera. Yes, go on, Mr. Reed. I'm with you. I just opened the case management system.
So, my lord, I was looking at the V file, and the reference is J63. If your lordship electronic pagination, that's page 65.
So I'm having like a two bundle under CMC. Both of them are 2nd of September. I'm not sure which one you're referring to. There are two linked CMC bundles. Which one you're referring to? Is it the 3rd of September or the 2nd of September?
I'm not looking at a CMC bundle, my lord. I'm looking at a bundle which I think on case lines will say will be. So let me go back to the index.
What's the date of the bundle?
Well, it's after the 7th of September. I just have an index starting with J, 3rd defendant's application, my lord. So this is the.
I do have it. Yeah.
Yes. So I'm gonna call that the V bundle, my lord.
Okay, I'm fine with that.
And then within that, if I could take your lordship to J.
It started with an index.
Yeah. And then
document file, yes.
And then if your lordship goes to page J56, you'll see an affidavit of Mr. Ali Sadr.
J56. Bear with me. Yes, I have it. Yes, I'm in.
Great. And then if you go to paragraph 25, my lord.
Right. Yes.
So you'll see. This is Mr. Sadr, who is giving an affidavit on behalf of Prime, the third defendant. And he says here, Prime has approximately 53 million dirham, which are held on its behalf by Renish, in circumstances where it, in brackets, Renish, and or Mr. Mehta has perpetrated a large-scale fraud. I believe that some question or graceful proceeds thereof are held by, and then it goes on. So essentially, both the claimant and the third defendant are making allegations of fraud against the first and second defendants.
Well, Mr. Reed, I think during my preparation for this hearing, I have come across this statement, and I have seen it. I had a complete trouble understanding this. In the same times, and looking at the other fact that Prime have forwarded the money back from its accounts to Renish for millions of dollars. I mean, to be honest, first of all, I had trouble understanding this. Prime has approximately 53 million against Renish. And then at the same time, the money goes from Prime accounts as receivables of sale of oil. And then the money bounced back to Renish. I don't know, I had that kind of trouble understanding these things.
Well, we say we have exactly the same trouble.
You share with me,
The trading relationship between Prime and Renish is, in our submission, extremely murky. Essentially, Prime is doing two things. First of all, it's using Renish to front payments, and secondly, it is supplying to Renish oil products from Iranian sources, which may obviously raise sanctions issues. But it's extremely unclear what the relevant flows of cash were within this trading relationship. It is said by Prime that Prime maintained no documents, that all of the relevant documentation was maintained by Renish, which we say is an extraordinary relationship of proximity. The two appear very much to be hand in glove. Prime now says it's surprised that within its trading relationship it is owed 53 million dirham, and that it, surprisingly, is the victim of a fraud in this relationship where it appears to have placed so much trust and confidence in Renish. But for the present purposes, for the purposes of the immediate judgment application, we say it is clear on any analysis that the first and second defendants are fraudsters. Even, we say, their co-conspirator is now accusing them of fraud in having absconded with 53 million dirham of Prime's money. In terms of the D1 and D2 absconding, leaving the jurisdiction, abandoning their premises in the UAE, that much too is agreed. And if one turns on within Mr. Sadra's affidavit to paragraphs 41 and 42, one has a strong sense of the tumbleweed blowing down the street, or the cobwebs, if you like, the spider's webs in the offices. So paragraph 41, this is Mr. Sadra speaking. On the 15th of July, I travelled to Renish's Alaska oil terminal located in the Hamria Free Zone and spoke to the operators there. To my horror, I was told that Renish's terminal had been locked down by one of Renish's lenders. I would have visited Renish's office in Dubai, but was told by others in the market that it had been closed and locked by banks/police, as all its lenders were chasing it for money. So D1 and D2 have left Dubai, they've left the UAE, they've absconded. We believe that Mr. Mehta has returned to India. Now, we say that there is clear evidence sufficient for a finding of fraud, trade finance fraud, obviously, where a party seeking trade finance ventures false pretenses or a false prospectus as to the trade they wish to finance. Now, sometimes that's just a little bit of a lie about what the relevant business activity to be financed is. But in the worst cases of trade finance, the fraudster constructs an entirely fictitious set of trading contracts, takes the finance and simply absconds, runs away with the money with no intention to make any repayment. And we say the trade finance fraud in this case is exactly that set of circumstances. So that's what we'll be arguing for in terms of the immediate judgment.
Well, if you allow me, Mr. Reid, I mean, first of all, I do understand your client position. I understand you're going for you claiming a fraud case in here. I know. I would remind you the standard of evidence that you be required to establish. And however, after all this understanding, I'm not inviting you to be very nice to your opponent in here, because we still have case. The case is going into apparently to trial. They're going to be court finding. I mean, I just want you to maybe use a less harsher language in this litigation. Towards Prime, at least. Yes, when it comes to the fraud and then the allegation of fraud as well. Until this, until this court has a finding. Go on, Mr. Reid.
Well, my lord, I think I'm allowed to say what our case is, and our case is that D1 and D2 were perpetrated trade finance fraud in that they provided false documents in relation to a fictitious transaction in order fraudulently to obtain finance from the claimant.
Right.
We seek a finding to that effect today in respect of Mr. Mehta and Renish, essentially the borrower under the fictitious trade finance and the personal guarantor of the fictitious trade finance. In respect of D3 Prime, of course it's true, and we accept that the allegations that Prime was party to that fraud remain to be determined and will go to trial. But I think I'm as level with you, my lord, in saying that the allegations that we make against D3, albeit unproven as yet, are that D3 was party to that fraud. And in seeking to defend the freezing order that your lordship made, we will be maintaining those allegations. We believe that there is sufficient prima facie evidence of fraud to defend the freezing order and to argue that it should not be varied in order to allow Prime to indulge in what it describes as its ordinary trading activities, whatever they may be, in circumstances where there is a real risk, given what has happened, that any payments for ordinary trading activities would be used to further dissipate assets by Prime. Now, I don't think...
When I see your case, I mean, a fraud should be a principle that stop Prime from asking to vary the order. Is that in your opinion, Mr. Reid?
Sorry, I'm sorry, my lord. I didn't I didn't hear the question.
I'm saying, I mean, from your side, bleeding a fraud case must work as a stopper that Prime should not seek to variation of the order. The fraud would stop them, I mean, seeking the variation of the order.
Well, we say, yeah, well, we say, first of all, they need to show a material change. Well, we're slightly straying into the third issue, but we'll say that they need to show a material change in circumstance. They would need to show that they are genuinely restarting trading activities. They have failed to demonstrate or evidence what those trading activities will be. In the past, they have shown complete contempt, we say, for orders of the court. Firstly, in terms of their continued movements of assets in 2019. Mm-hmm. Secondly, insofar as their failure to provide asset disclosure until June of this year, and even when they did, providing asset disclosure that was, we say, insufficient. And thirdly, we say there's very significant evidence of fraud on their part, that they are party to the fraud. And in those circumstances where there can be no trust in Prime, in the third defendant, we say it's inappropriate to vary the order that's already been made and that has been upheld on the return date. And obviously, insofar as part of that case, it's saying that we have strong allegations of fraud, which we intend to prove at trial. Part of that case is those are serious allegations, and I accept that they have to be upheld by cogent evidence, even on a basis of whether they're arguable and whether there's a strongly arguable case for the purpose of getting and supporting a freezing injunction.
Yeah, I see your point, yes.
So, my lords, that's the first issue, the immediate judgment application, both as against the first and the second defendants. The second matter for hearing are the CMC directions, and I'm pleased to say that the parties are substantially in agreement insofar as there are the fraud allegations proceed to trial as against D3. There are only 2 points of substantial difference. Firstly, the claimant wants expert accountancy evidence, and you will have seen in their case management information sheet that they say a forensic accountancy expert may be required in due course. Yes. And we say that hardly satisfies the test of necessity under the rules of the DFC court, and we say it's extremely unclear as to what it is this expert's going to be doing. It's said that the expert is going to be seeking to reconstruct the trading relationships between Renish and Prime, presumably in the absence of any documents that have been maintained or retained by Prime. Mm-hmm. The second issue is trial date. It appears that both counsel are available from the 7th of February. It appears further, however, that it's no longer convenient for the third defendant. They have ventured 2 reasons. Firstly, they've said counsel will struggle in that he has some hearing before or after the relevant week. And secondly, it said that the trial date in February would be unrealistic, and we understand that suggestion to be made by reference to the need for expert evidence. Although we don't entirely understand why the involvement of an expert would need to push matters or push the trial from February into May or June, as is now sought. And the third issue, my lord, which is for hearing this morning or today, is the third defendant's application to vary the freezing order that was made back in 2018. That obviously is Prime's application. We say that it doesn't show a material change of circumstance, and we say that when you look in the circumstances of historic, highly dubious and suspicious trading. When you look at long period of contempt, both in terms of freezing order and in terms of the provision of information, even when they concede that they were aware both of the proceedings and of the order from October of 2019, we say there is a real risk that any ordinary trading would be a pretext or would permit dissipation, and therefore there's a real risk of that dissipation. There has been a proposal of compromise made by the third defendant suggesting a notification regime, but that would essentially involve the claimant being told every time a large payment was about to be made out by Prime, and in the circumstances of Prime's trading, it would be extraordinarily hard, both for the claimant and ultimately for the court, to investigate what that payment was and who the recipient was and whether it was a genuine trading payment or whether it was a dissipation or a payment out by Prime with a view to getting its assets out of away from any potential recovery or enforcement by the claimant. Now, in terms of the background, SBM, as you'll be aware, was approached by Renish for trade finance. This sort of finance is used to bridge the delay between a payment to a supplier, which is
Mr. Reid, if you allow me, we might need to maybe refer to Mr. Page if you want to say anything, like any housekeeping point or anything before you just start your first limb of this trial. Mr. Page, if you're still with us, if there is any matter you want to raise before Mr. Reid can go on?
My lord, I'm content with Mr. Reid's proposal to deal with the immediate judgment application first, then if we deal with case management directions before then going on to my application. Obviously, much of what Mr. Reid has said has strayed into argument, and I'll be responding to that in far more detail in due course. But I don't seek to take Mr. Reid out of his stride now, and I think we probably should crack on with it.
That's very good. Thank you. Go on, Mr. Reid. Yes.
I'm grateful to Mr. Page, and I'm grateful to you, my lord. The trade finance, as I say, is bridging the payment by the supplier and the later payment by the purchaser, which was said in these arrangements to be Lanka, a Sri Lankan oil company. Yep. In terms of understanding the finance, possibly the easiest way to understand it is, in fact, to look at the offer letter. So if I could take your lordship to what I call the master bundle, they also alternatively called the hearing bundle. Mm-hmm. And if I could take your lordship to page D472.
Give me seconds, it's downloading. You said D. I didn't have D. 1 second, so this one starts from...
If your lordship has it in PDF and wants the electronic pagination, it is 636.
The evidence, you say evidence of the claimant, isn't it?
Well, I'm looking at something called the hearing bundle or the master bundle.
I do have different naming, by the way, Mr. Reid, than the one you have. I'll tell you what is the how my bundles tag. Bundle, application to vary terms, freezing order, CMC bundle 1, CMC bundle 2, bundle for application to vary term of freezing order, bundle for claimant, application for immediate judgments. So
could we have a look at the last bundle, my lords?
Yes.
And does it have a tab D, i.e. a section with pagination under the letter D delta?
It's coming up. Please bear with me, it's downloading. Yeah, it does have D, and under D there are 8 different tags. Yes, the D code evidence, application for immediate judgment, yes.
Yes, and if your lordship goes to page D472.
D47, 1 second. D472, yes. Thank you, Ayman.
So this is an offer letter dated the 31st of October 2017. So a few days before the facility agreement was entered in November. And then the key terms of the finance agreement are set out in this offer letter in a way that's easy to see. So first paragraph, we're pleased to advise that your request for banking facilities has been approved by the bank, subject to the terms and conditions. The lender is SBM, the borrower is Renish. And then at the bottom of the page, you see the facilities. So $30 million of trade finance and 10 million of a Forex line. Mm-hmm. And then one sees over page D473 the key terms in terms of trade finance and the limit of $30 million. If one goes on to D474,
yes,
you see there the purpose stated by the first whole. This limit may be used to finance working capital in the normal course of business and bid for contracts in favour of majors such as, so the purchasers have to be major purchasers, and amongst those one sees various state oil companies, including Lanka, based in Colombo in Sri Lanka. Certain products are listed, including fuel oil, and then over page at D475,
yes,
you see in the bullets at the top of the page, client also do small purchases with the following local buyers, and then at the bottom of that list, Prime Energy. So SBM, in offering this trade finance, has been very particular about the product. It's very particular about the end purchaser, very particular about the entities from which the products may be bought. And then also on page D475, one sees the periods of, for each loan, and they are between 60 and 90 days. And then in terms of interest, if one goes over page to 476, D476, one sees the second box, interest for import loans, and then for financing of contracts awarded by state organizations. So that would be where a contract was placed by an organization such as Lanka. Interest on each loan and invoice discounting denominated in US dollars will be charged on daily balances at 2.25% per annum. So that's essentially the basic interest rate. And then if we turn on a few pages to 479.
Yes.
Where it deals with security. The first item of security is a personal guarantee of the promoter, Mr. Hiteshkumar Chinubhai Mehta. And then further down the same list, 2.1.8, one sees a promissory note in favour of the bank. And then one has default interest at the bottom of page 479. And then the last paragraph of that, so in the event of default, the borrower and or guarantor will, by way of penalty, have to pay additional interest on the unpaid sums overdrawings at the rate of 5% per annum on banking facilities denominated in Mauritius and Mauritian rupees, and at the rate of 2% per annum on the banking facilities denominated in foreign currencies. So 2% is the default rate of additional interest under this facility agreement. And I think we can then go on to 488.
So, Mr. Reid, this 2% will be added from the event of default only. Not it will not apply to the whole period of the loan, isn't it?
No, it's that your lordship's absolutely right. That's from the time of default. It's 2.25% is the basic rate above LIBOR, and then additional 2% of default interest from the time of default, and then 488. One sees there that this has been signed as being read and approved by Mr. Hitesh Mehta on the 12th of November, which as one will note is the date of the facility agreement, for on behalf of Renish and the first defendant, and also again by Mr. Mehta on his own behalf as director of Renish. So that's if you like, a counter through the main provisions of the facility agreement. The facility agreement itself is at page D105. Sorry, D91, I apologize, it was a wrong reference.
Just a D91, yes.
And I don't think I need to take you through the detail of the drafting of a much longer facility agreement, but essentially those terms signed by Mr. Mehta on the 12th of November in his signature of the offer letter essentially are set out as a matter of extensive legal drafting in the facility agreement. And it's in clause 2.1 that the lender agrees to make the facility available. The interest provisions are in clauses 10 and 11. So if we could look quickly at those. So clause 10 is at page D115.
Yes, interesting.
Yes, so interest, 10.1a, financing contracts awarded by state organisations. Interest on each import loan facility shall be charged on daily balances at 2.25% above LIBOR. That's just as we've seen in the offer letter. And then if I could take you over page to the default interest under clause 11, and your lordship will see there at 11.4 the provision for default interest at 2%.
Yes, again, yes.
Yeah. And your lordship may have seen the schedule attached to our skeleton argument, which refers to those two rates of interest under
the calculation, yes. Yeah.
Respectively. The personal guarantee is just let me find that, sorry. That's at page D161, my lord.
You said D161?
D161, my lord, in the same bundle. Hiteshkumar Mehta in favour of SBM, and then reference in the recitals to the facility and to the guarantee being given. And then if I could take your lordship on to page D164.
Yes.
Your lordship there sees the guarantee and indemnity provision in clause 3. So the guarantor hereby irrevocably and unconditionally guarantees the bank punctual performance by the borrower of the guaranteed liabilities to the extent of the facility amount and all applicable interest, including all amounts of default interest, costs, charges and fees owed by the borrower to the bank. And B, undertakes to the bank that whenever the borrower does not pay any amount when due under or in connection with the finance documents, he shall immediately pay that amount as if he were the principal debtor. So he steps into the shoes, if you like, of the principal debtor.
Yes, yes.
Now, the fraud, we say, is in the sham transaction, the fictitious transaction, which was used by Mr. Mehta and Mr. Ahmed in seeking the trade finance. The transaction that was proposed was entirely within the terms of the offer letter, as we've seen. So Prime was one of the suppliers we saw in the offer letter, and Lanka was one of the state oil companies that was a purchaser for which SBM was willing to finance any relevant trade. SBM was provided with a number of contractual documents, which your Lordship will have seen in the master bundle. If I could take your Lordship to page D276.
D76?
Yes, sorry, D276. I'm sorry about that.
Amen. Yes.
So this is a Lanka purporting to purchase a significant amount of fuel oil. So you'll see beneath the table, we are pleased to accept your offer for the supply of 72,000 metric tons fuel oil on DAP basis at Colombo during May-August 2018, divided into 3 parcels, each of around 24,000 metric tons. So this is a purported purchase. I should say that the claimant has written to Lanka asking them to confirm that this represents a genuine trade, and Lanka have entirely failed to confirm or declined to confirm that this represents a genuine purchase on their behalf. There are then various documents in respect of the parcels, and one sees, if one turns over page to D277, a contract with Prime. So Prime is said to be the supplier of the oil, which will then be provided by Renish to Lanka as the onward purchaser. And so this is on the 16th of April 2018, subject contract for the sale of 24,000 metric tons of fuel oil to Dar Khorfakhan in the United Arab Emirates, to confirm agreement reached on the 16th of April 2018. The seller, and at the bottom, quantity, the seller shall supply fuel oil quantity 24,000 metric tons. And then if one goes on to page 284, 284,
Yes.
One sees notices by telefax email should be sent to the seller at the following correspondence addresses, and then there is a Prime email address, rpshipping@primeenergyme.com, which has been confirmed to be an email address owned and controlled by Prime. One then has what appears to be the stamp of Prime Energy, or Prime, the third defendant. And one then sees over page at D285
yes,
a purported notice of assignment to Lanka, and then at page 287, sorry, D287, an acknowledgement of assignment, again purportedly by Lanka, and one then sees at page D303, if one skips over a number of other Prime alleged or fraudulent forged Prime documents, one sees a pro forma invoice in respect of one of the parcels. So shipper is Prime, buyer is Renish, and an invoice with a date and a quantity 26,400 metric tons of fuel oil, an amount, and payment requested into an account, which I'll call the Prime account in the National Bank of Kuwait. And then there are, again, further pro forma invoices. Now, all of these documents we have just been looking at after the facility agreement and the personal guarantee, all of these documents are false. And indeed, that is common ground. So in the list of issues, it is accepted as common ground that these documents are false. Perhaps it's worth quickly looking at the list of issues. That, unfortunately, is in the CMC bundle. And that is at
Are you saying, Mr. Reed, that even the prime position is that all of these documents are false, even the one referred to as a prime document?
Yes, the transaction has been disowned. None of the parties accept or assert that this is a real transaction. This is fiction. This transaction is made up, and these documents have been made up to evidence a fictitious transaction. And for that reason, it's possibly worth looking quickly at the list of issues, which is in the CMC bundle at I-14.
CMC. The page I-14, isn't it?
Yes, that's right. And it's on page I-14. One has the common ground. So the parties have helpfully managed to agree a certain amount. This is the parties for these purposes being SBM and Prime.
Yes, list of issues.
It's two, the third defendant Prime did not intend to and did not in fact enter into any transaction with Renish or Lanka in respect of the supply of fuel oil to Lanka.
What are you reading? I can't see this.
Oh, sorry, my lord. I'm still on page I-14 on the list of issues.
Yes, the common ground.
Common ground. So this is what the parties agree. The parties agree, or Prime, that Prime did not intend to and did not in fact enter into any transaction with Renish or Lanka. So all of that contractual documentation has been made up. It does not reflect any reality. Now, Prime is essentially, by implication, saying that this was a fiction made up by Renish and Mr. Mehta. We say that Prime was party to that conspiracy. That's a matter. The involvement of Prime is a matter for trial, but all parties now before the court accept that the transaction used to obtain trade finance, i.e., that oil would be bought from Prime and shipped on through the to Lanka, is made up, and that all the documents you have just looked at are fraudulent, are forged. And if you need further authority, that one goes to the defence, which one goes back to the hearing bundle. And the defence of Prime is at B82. And at paragraph 26 of the defence, page B43, Lord.
B43.
B Bravo 43.
Please bear with me.
No, I completely understand. I think all of us have struggled with case lines over the last few days.
I think the problem is not with the case line. It's, I think, with the filing and case line, and because I've been using the case line since March, it's working very well, even in more complex cases.
I tend to find, my lord, that most advocates are downloading the files as PDFs, which allows you to navigate much more quickly than the system does.
No, I'm seeing. I mean, I'm having even my CPO is sending me the link of the page. It's open up, then it's disappear again.
Very, very helpful. Good. Right. Well, if we're looking at page B43, my lord.
So is it in the main bundle, isn't it? You said
It's in the main bundle.
It's in the main bundle.
Page B43.
Main bundle. B43, isn't it?
Yes, my lord.
Yes, I'm there finally. Yes.
So we have D. This is prime pleading in respect of the facility agreement. The paragraph 26.2.
Yes.
And then, if and to the extent that Messrs. Ahmed and/or Mehta represented to SPM that the loan advances were to be paid for prime for the supply of fuel oil to Lanka, such representations were untrue. Neither Prime itself, nor Mr. Sadr, nor Mr. Farhan, nor anyone else with actual or ostensible authority from Prime had any dealings with Lanka. There was no negotiation, contract, or other agreement for Prime to supply fuel oil or any other commodity to Lanka, either its own behalf or on behalf of a third party. So that is a clear and categorical denial by Prime that it was in any way involved with any negotiation or contract relating to the fictitious trade between under which oil would be purchased from Prime and sold on to Lanka. So it is clear, we say, that all of those documents are forged and that the basis on which the trade finance was obtained from SBM was false. And we say in those circumstances, not least where D1 and D2, where Renish and Mr. Mehta have gone to ground, not only can this and have failed to engage at all with the proceedings of this court, we say in those circumstances it is quite the court should make a finding of immediate judgment against D1 and D2, both on the basis of their contractual obligations under the facility agreement and the personal guarantee, and also on the basis of the trade finance fraud in the representations as to the trading that were made in order to obtain that trade finance. Now, the finance, as you'll see, was disbursed. If one goes in the same bundle back to the particulars, and if one goes, sorry, which is at page B7,
yes.
And if we look at paragraph 13 within the particulars, your lordship sees there the 4 payments that were made by SBM under the trade finance, under the facility agreement, pursuant to the alleged trade. So those are 4 payments there. They are 19th of March, 24th of April, 22nd of May, 6th of June. So essentially one a month in sums of around $10 million. Each of those payments is accepted as being common ground in the list of issues. I don't think I need to take your lordship to it, back to it. It's at I-14, but all of those payments are accepted by Prime as having been made. Your lordship has the SWIFTs at page D305, so further on in this bundle. D305, Delta 305, my lord.
Yes, I have it.
So these are the SWIFTs. They're often quite hard to read, but essentially 305, Sender State Bank of Mauritius, about halfway down page 305. And then one sees the value. So this first SWIFT is 13,751,100. That's the third payment of the payments we were just looking at in the particulars of claim.
Mm-hmm.
The order, it is paid to Renish, and you see that there with its office HGS Tower in.
Wait, you looking to the receiver? Or?
Yes, that's the receiver. So the party that receives the money is Renish,
yeah.
and is actually the receiver. Thank you. and then the institution and the receiver has an account with institution. That's the bottom line of page 305, and you'll see, just turning over page D306, the bank into which the monies were received with the National Bank of Kuwait. And I don't remember if your lordship remembers, but there was a sort of jurisdictional battle that was a challenge that was made by MBK, which was the receiving bank, and they brought a JJC challenge which was comprehensively rejected by the JJC, which found that the DFC court had jurisdiction. I should say that the NBK, National Bank of Kuwait, in fact, notwithstanding its jurisdictional challenge, froze the accounts of Prime, the Prime accounts, Prime account into which the monies were paid. Sorry, I realised I just made a mistake. Renish is the party to whom the finance is provided. The receiver, and I apologise, I'm correcting myself. The receiver in page D306 is Prime. The beneficiary, as it's called in banking terms, is called the Prime is Prime. Yeah. So the monies are paid into the Prime account with NBK. I should say the Prime account was in fact frozen, and indeed all of Prime's accounts with NBK, there being a euro account, a dollar account, and a dirham account, all of those accounts were frozen by NBK. Looking still at this SWIFT, one sees F70, so top of page D306, remittance information, purchase of fuel, payment against pro forma invoice. So once again, one sees reference to reliance on the fraudulent forged documentation, the pro forma invoice we've just looked at, in order to obtain the release of funds into the Prime account with MBK. So that's the SWIFTs. There are promissory notes, which, well, first of all, if one goes to D272,
yes,
one sees a promissory note in respect of the broad trading in a very substantial dirham sum. So Renish to SBM, and then for value received, I, the borrower, promise and unconditionally undertake to pay on demand the lender to the order, the principal sum of 147 million dirhams. So that covers globally the purported or alleged trading. And then there are a number of promissory notes dealing with specific amounts reflecting the specific payments. So, and they start within the bundle at D311.
D311.
Does your lordship have that?
I do.
So the first one here is on the 20th of June 2018, we, Renish, shall pay to SBM or order the equivalent in Mauritian rupees foreign currency of $8.8 million odd plus interest for 60 days. So that sets out the terms of the particular payment made and makes a promise to repay the principal amount plus interest. And these secondary promissory notes, which one sees in the following pages, are helpful in terms of setting out exactly what was paid in US dollars, when the interest, the number of days for which the loan was made. You see the interest there. So 3 monthly LIBOR plus 2.25%. So the interest rate is specified, the number of days is specified, the repayment is specified, and the payment date. So all of the key information appears in these secondary promissory notes. So we have a suite of documentation and evidence. We have evidence that the payments were made in the SWIFT, evidence that the monies were paid into the Prime account with NBK, evidence that they were paid against invoices that we now know to be false. We have promissory notes in which contractual promises are made to repay the sums advanced, creating a liability in addition to the liability under the facility agreement and under the personal guarantee. And you will have seen, my lord, in the attachment, the schedule to our skeleton, essentially a summary of the 4 payments that have been pleaded and agreed by the third defendant to have been made, the maturity dates under each, the interest under clause 10, so that's the basic 2.25% above LIBOR, and then the default or the additional interest from the maturity date and the total outstanding. And your Lordship will have seen reference to a set-off and to some partial repayments. But what is now outstanding is the total number at the bottom right-hand corner of $31,245,932.94. I should say, in respect of the acceleration, insofar as it's relevant, given that the terms have long expired anyway, the acceleration notice can be found at B29 in the same bundle.
B29.
Yes.
Okay.
So this was served on the 1st of August, the day before the without notice hearing before your Lordship, at which the freezing order was made. And then if one goes to page B30, third paragraph down, the amounts outstanding under the facility agreement as of the date of this letter are not less than 30 million odd US dollars in aggregate, the sum due. SBM hereby notifies Renish that pursuant to clause 17(1)(s) of the facility agreement, SBM is entitled to and hereby accelerates the sum due and all other sums due by Renish to SBM. So as at that date, all sums outstanding became due and owing pursuant to the acceleration, pursuant to that notice. By this stage, it should be noted that the defendants had vanished, and we say this confirms the very strong prima facie evidence of fraud. By mid-July, Mr. Mehta had stopped responding to communications. The last communication we had from him was a WhatsApp communication. Your Lordship has that in this same bundle at page D532.
532D, yes.
And that is a WhatsApp communication of the 12th of July. And Mr. Mehta, you'll see the white text box, speak. Monday, I will back with all solutions. Monday being the 16th of July. So he not only did he not get back on Monday, the 16th of July, but in fact, he has never since responded to any communications. The offices of Renish were an office building in the Hamria Free Zone and a Dubai office in the Dubai Lakes Towers, in the HDS Tower. Both of those have been abandoned. We've seen the evidence of Mr. Saad as to the abandonment. Your Lordship, remember from the hearing in the application for the freezing order, a report by some investigators called Artemis, who themselves carried out an investigation and themselves found both of those offices to be abandoned.
Sorry,
my Lord?
I recall that, yeah.
Good, I'm grateful. It's perhaps worth looking at the, for example, at the HDS Tower office, and that's at page D363.
Yes.
So one sees there at the bottom of the page, Renish, Dubai. Renish's main office is located 37th floor, HDS Tower Cluster, Dubai Lakes Towers, Dubai. And then if one goes over page to 364, about 3 paragraphs from the bottom of page D364, upon exiting the elevator, Arena Offshore was not found. However, the office closest to the elevators appeared to be ESCO Renish Group of Companies, and there was a large silver sign setting displaying this. The office was closed. The doors were locked during the time of the visit. Mail was found dropped in front of the glass doors, including an edition of Gulf News newspaper dated 31st July. It was possible to look inside the office because the doors were glass. It could be seen that just to the left of the entrance, a chair was left in the middle of the hallway, indicating that the office had not been used. It clearly looked like the office had been abandoned, and there was no sign of any activity or occupancy. And indeed, if one goes over page, a visit is paid to Mr. Mehta's home residence, and he's found to be absent. So no one was in the apartment at the time of the visit. So we say it is clear that Renish has ceased all business. Its office has been abandoned. Mr. Mehta has failed to respond to any communication. There's no indication that he's in the UAE. And you'll recall that he's given at various times a permanent address in Gujarat in India. So we say the fact that the defendants, the first and second defendants, have vanished or have left the jurisdiction is yet more evidence of their involvement in trade finance fraud. The application for freezing orders made on an order was made on the 2nd of August. It was continued on the 7th of August. In terms of the service of the order, if your lordship could go to page D536.
Yes.
This is the letter under cover of which the order was served. Then your lordship will see that it was served on Renish at its office in the HDS Tower in the Dubai Lakes Towers. It was served on Renish at its Hamria Free Zone office. It was served on Mr. Mehta at his residential address, again in Jumeirah, and it was served on Prime at its Hamria Free Zone office, PO Box and registered office. And you'll see from and it was also served on various email addresses, which include a number of Renish addresses which had been used in the course of negotiating the purported trade finance. And one sees too RP Shipping, which is a Prime Energy address which was owned and controlled by Prime. So fairly comprehensive service, as one would expect of an order of this significance, but there was no response either from the first defendant or the second defendant, or indeed the third defendant. And you'll be aware that Mr. Sadra has claimed on behalf of the third defendant that they only became aware of the case in August 2019 and only became aware of the order in October 2019. Now we say if this were not enough, there are yet further indications of fraud. NBK provided a full set of bank statements in respect to the Prime account pursuant to the disclosure order made on the 7th of August when your lordship continued the freezing injunction. And these showed that the payments, from the Prime account. Now, we have to go, unfortunately, back to the list of issues, which is back in the CMC bundle. Our list of issues.
Yes.
And then at paragraph 3, the following sums, so common ground, the following sums were transferred from SBN into an account in the name of Prime with the National Bank of Kuwait. So those are the sums which you've just discussed, which were paid, the 4 payments. And then paragraph 4, each of the above payments into Prime's account was dissipated within 1 to 3 days, as alleged in paragraphs 56 to 58 of the particulars of claim. So an admission of paragraphs 56 to 58 in respect of the payment of monies out of Prime's account with NBK. If we could go back into the main bundle and back to the particulars of claim, and if we could look at the paragraphs to which reference is made in i.e. paragraphs 56 to 58, and apologise for having to navigate.
Give me the reference back. This is B what? Again?
Sorry, this is B. I'm looking at page B22.
I see. Okay.
So this is the paragraphs within the particulars of claim that are admitted are paragraphs 56 to 58.
Right. Yeah.
So paragraph 56 at page B22.
I have it, yes. Yeah.
For example, on the 23rd of May, this is dealing with the third payment. Prime made two transfers of $5.6 million and $1.5 million, respectively, to Renish. Now, just by way of example, as soon as this money hits the Prime account, purportedly as trade finance to Prime as a seller, Prime immediately, or almost immediately, transfers round sum numbers, 5.6 million, 1.5 million, back to Renish. And we say, so where the trade finance, in a trade finance fraud, is paid out to the purported seller under the purported trade, but then is immediately paid back to Renish, to the party, the trader that purports to be trading and has obtained trade finance accordingly, that in itself is extraordinarily doubtful, dubious, and suspicious. And one can go on to look at the transfers. So another transfer is made, 1.43 million to Petrochem, which we understand to be an entity related to Renish. In paragraph 57, the fourth payment. So again, $200,000 and $1 million to unidentified accounts. Now, these don't appear to be paying particular liabilities in specific sums. They just appear to be payments of round sum amounts, essentially dispersing, we would say, the proceeds of fraud to other parties who will then in turn disperse it further. It is a classic pattern of any fraud, and particularly of sophisticated trade finance. And again, in respect to the fourth payment, one sees an amount, 675,000, paid back to Renish, which purported to be the trader rather than a supplier entitled to payment for any relevant trade. And then at the bottom, paragraph 58, again, still accepted in the list of issues as common ground, one sees the following amounts disbursed by Prime. And one sees two obvious points. Firstly, 11 million is then distributed to by way of internal transfers to Prime. So it's sent into other Prime accounts. And again, 7.8 million to Renish, 3.4 million to Petrochem, which is a company, an entity related to Renish, in that it appears to be owned and directed by Mr. Ahmed, who is a Renish employee and director.
Yeah.
So the circularity of this funding, so trade finance provided purportedly to Prime as the seller, but actually going straight back to the trader, which is Renish and Mr. Mehta, who then abscond in circumstances where all the trade finance documentation relied on in providing the finance and in paying out, as recorded in the SWIFTs, is we say, clearly the process of fraud. And we say the evidence of that fraud is overwhelming. And we would add to that the fact that Prime 2 has ceased operations, and we would add to that the fact that Prime, which we say is another conspirator, has, in our submission, failed to comply with the freezing injunction, failed to comply until very recently, and only partially then, with the provision of information order. And we note too that the extremely suspicious circumstances around the re-engagement by Prime with the court process, said to be because it only belatedly discovered the existence of the proceedings and the existence of the order. But we say it would have been clear to Prime from the get-go that its accounts had been frozen by NBK. Prime says it was just told that they were frozen for compliance reasons, but it must have known that that would be pursuant to some process. No effort was made to investigate that process, and in those circumstances, we say that the re-engagement, or the engagement by Prime with the court was not as a result of delays in finding out about the proceedings or the order, but arose from a strategic decision that it was in the best interest of Prime and possibly Renish to engage with the court rather than simply to ignore the court at that time. So we say, my lord, that all of those are significant indicia of trade finance fraud, and there is an ample basis for this court, as a matter of immediate judgment, to make a finding of fraud as against fraudulent misrepresentation as against Renish and Mr. Mehta. The judgment itself could just be made on the basis of the contractual claims, i.e. the failure to repay the monies lent to the first defendant. But we say the evidence on the fraud claim is overwhelming when one looks at the documentation. It's clearly deliberate in terms of misleading SBM. It's clearly intended to procure finance. The forged documents are used in obtaining the finance, and indeed the finance is only released on site of the pro forma invoices. And D1 and D2, Mr. Mehta and Renish, have closed down and absconded. We say in those circumstances it is an entirely proper case for immediate judgment to be granted. There may be an issue, and your lordship may ask why a default judgment should not be preferred. Your lordship will have seen what we say in our skeleton. In terms of common law enforcement, it almost always, in almost all common law jurisdictions, requires a judgment on the merits, and so a default judgment is simply, in real terms, unenforceable internationally. And one gets that common law principle from Dicey. And I don't know if your lordship, within the main bundle, could turn to F56.
F56, yeah.
Yes, F56.
Yeah.
And your lordship has there, Dicey is a difficult text, but it essentially crystallizes core principles and rules of common law. And they're often fairly obscure, but this one is admirable in its clarity. Rule 48, at page F56, a foreign judgment which is final and conclusive on the merits and not unimpeachable under any of rules 49 to 52 is conclusive as to any matter thereby adjudicated upon and cannot be impeached for any error, either one of fact or two of law. So a judgment to be enforced under common law enforcement without being impeached needs to be a judgment on the merits. Most common law jurisdictions then have a statutory or a treaty overlay. In the case of India, that's the Indian Civil Procedure Code. And within the DIFC context, that is explained by some DIFC court guidance, which your lordship has in the file. I probably don't need to take your lordship to that guidance because it's easier to look at the underlying texts. So one can start with the Indian CPC, which your lordship should have F69. And then yes. If I could take your lordship to Article 44A within that, which is at F77. Does your lordship have F77?
Yes, I do.
So the title, Article 44A, execution of decrees passed by courts in reciprocating territory. Whereas a certified copy of a decree of any superior courts of any reciprocating territory has been filed in a district court, the decree may be executed in India as if passed by the district court. And then just jumping down a couple of paragraphs, explanation 1, reciprocating territory means any territory outside India which the central government may, by notification in the official gazette, declare to be a reciprocating territory for the purposes of this section. And then if I could take your lordship briefly to the Gazette of India at page F79, and your lordship will be very familiar with the very exciting news that we all had in January this year. That
what's the reference again, Mr. Reid?
Sorry, F79, well, F77 was Article...
Yeah, I've seen that. The new reference, 79.
I was taking you to the Gazette of India.
Yeah, I got it, yes.
And we'll see some Sanskrit at the top. And then at page F79, and your lordship will be aware of the 2020 declaration by which the UAE and India agreed to enforce each other's judgments, which is exciting, particularly for those in Dubai. And the notification is therefore in the Gazette as follows. In exercise of the powers conferred by explanation 1, the central government hereby declares UAE to be a reciprocating territory for the purposes of said section, and the following courts in the UAE to be superior courts of that territory, namely, and then when one looks down at 2 local courts, little e, courts of the Dubai International Finance Centre. So, pursuant to this notification in the 2020 declaration, the DIFC courts are superior courts of a reciprocating territory, that's to say the UAE, and therefore under 44A, the Indian courts will enforce orders of the DIFC courts. Very, very exciting, really opens vast possibilities of enforcement against Indian defendants who have absconded to or are resident in India, which was previously extremely hard to enforce judgments. The only issue, though, is at page F76, which is Article 13 of the Indian CPC. Page F76, my lord.
F76, okay.
And there one sees Article 13, when foreign judgment not conclusive. A foreign judgment shall be conclusive as to any matter thereby directly adjudicated upon between the same parties or between parties under whom they or any of them claim litigating under the same title, except, and then little b, where it has not been given on the merits of the case. So we say if this court is going to give an order against Renish, Renish and Mr. Mehta, that is susceptible to enforcement in India, that order needs to be made on the merits. I need to, as I hope I have, taken the court through our case, explained the case, referred to the documents in such a way that the court is able to give a judgment on the merits, not merely to give judgment by reason of the fact that D1, D2 have failed to acknowledge service or have failed to enter a defence, but the judgment of the court would be given, albeit on an immediate basis, by reference to the merits on the evidence that has been carefully laid before the court by those instructing me. That, I should say, is the court's view. Your Lordship will remember an order made in July 2019. That's again in the same bundle at C23.
Yes.
Sorry, misreference.
No, I think this is wrong reference.
Sorry.
This is your own case.
Your Lordship will bear with me. I'll get it.
Take your time.
Sorry, I have page C23 in the main bundle. It's an order of yourself, of your Lordship.
Yes.
And you'll see the recital at the bottom of this page. So, an order made by you, 16th July 2019, upon the court concluding that it's appropriate for the claim as against the first, second, and third defendants to be considered as a hearing for immediate judgment. The third defendant hadn't popped up, if I can put it that way, by this stage.
Yep, yes.
Then the order made, and you'll see paragraph 2 of the order, at the hearing, the court will determine whether immediate judgment will be entered as against first, second, and third defendants pursuant to Rule 2410. So your Lordship was accepting that the hearing of an application for immediate judgment was appropriate. Now, your Lordship will be very familiar with the test for immediate judgment. The real issue is whether a case needs to proceed to a trial. Is the court going to be better placed to enter judgment by having a process of disclosure, witness statements, even experts? And is that necessary in order for the court to enter judgment? RDC 24 itself refers obviously to the defendant having real prospects of successfully defending the claim, and the authorities are clear that real prospects must be realistic. They must be more than merely arguable. So sometimes parties suggest that the test is whether the case is arguable, whether the defence is arguable. Well, it's more than that. The defence has to be more than merely arguable. It has to have realistic prospects, taking a long, hard look at the evidence. Is it realistic to say that the first and second defendants are not required to repay the monies or to pay damages for the trade finance fraud in advancing those documents and in making representations as to trading as between Prime and Lanka? And we say it's simply not realistic on any basis to suggest D1 and D2 are not liable. And that's even just on the evidence adduced by SBM, and even ignoring the evidential burden, which we say is plainly on the defendant. I should just say, in terms of the authorities, it is worth looking at just one authority, which is the IGPL case in the Court of Appeal, and that is at F18.
Right.
Sorry, I've lost my internal reference. Sorry, my lord, will you just bear with me while I find the...
No worries.
Yes, sorry, page F30, my lord.
I'm in F30, yes.
I'm going to pick up at paragraph 57. The test for immediate judgment is whether IGPL had no real prospect of succeeding in defending SCB's claim. The Court of Appeal must therefore consider whether IGPL had a realistic as opposed to a fanciful prospect of success. And then at 58, while the legal burden of proof for immediate judgment rests with it, Standard Chartered submits that the evidential burden of proving that IGPL had a real prospect of successfully defending Standard Chartered's claim rests with IGPL. That's to say the defendant. I agree with Standard Charter's position. So the Court of Appeal, they're confirmed that the evidential burden is on the respondent to an application for immediate judgment. So it's for the respondents, it's for D1 and D2 to show any matter of fact on which it relies. Now, obviously in this case, the respondents haven't engaged with the court, they haven't turned up, they haven't sought to make or advance or make good any defence, they haven't sought to rely on any evidence. And we say that should be enough for immediate judgment. Even if it isn't, we have very carefully laid out the evidence of both the contractual entitlements to be repaid and for the guarantee to be paid, but also the evidence of our claim to damages in fraud, given the trade finance fraud in setting up a fictitious transaction which simply didn't exist, and indeed in creating documents which are fraudulent to support that and to obtain the release of monies under the trade finance. Now, in the skeleton, we've set out what we say the core findings required are in order to make enter judgment on the merits. Just very quickly, the facility agreement at page D1, the personal guarantee at D161, the advancing of funds as evidenced by the SWIFT at D305 and following. The deadlines for payment are clearly set out in the promissory notes that we've looked at D311 and following. The acceleration notice at B29, the absence of any payment, whether under the facility agreement, the guarantee, or the payment, the promissory notes, clearly a breach of contractual obligations. And then the interest calculation as attached to the skeleton argument. I've taken your lordship to the interest provisions, both in the offer letter and in the facility agreement. And then in terms of the findings of fraud, which we say will assist potentially in gaining post-judgment injunctive relief, possibly in India and other jurisdictions. It's important that the foreign court understands the defendants with which it is dealing. And we say that inference arises on a number of primary facts. We say the back-to-back contracts, which were never agreed never in fact agreed, the contractual documents, which we say are forgery, the partial repayments, which were made only to induce SBM to lend further until the full extent of the facility had been advanced. The fact that Renish and Mehta have ceased all communications, the fact that Renish has abandoned its offices, the fact that Mr. Mehta has absconded, and the contempt shown by both Renish and Mr. Mehta of both the freezing order and the provision of information, showing clear bad faith in circumstances where the orders were sent to email addresses used by them in the course of their negotiation and their management of the trade finance, the facility agreement. And finally, the circular payments by which monies came back to Renish and were paid swiftly back to Renish out of the prime account with MBK as accepted in the list of issues, the common ground. And those critical paragraphs in the particulars claim 56 to 58, which are accepted in the list of issues. We say that that is a more than sufficient basis for a finding of fraud in entering judgment, immediate judgment, as against the first and second defendants. And I should just say very quickly that we would also seek costs on the indemnity basis, not only because we were entitled under indemnity in the facility agreement and the guarantee to the claimant's costs, but we say that when one looks at the fraud in this case, when one looks at the failure to engage with the proceedings, when one looks at the contempt in dealing with the orders made by this court, this is clear. These are clearly facts which take the case away from the norm and show abusive and improper behaviour. So we do seek costs on the indemnity basis. So, my Lord, those are my submissions in seeking immediate judgment. If I can assist the court further.
Well, thank you very much. I mean, according to your proposal first, I thought the immediate judgment application might take only half an hour. But apparently it took just 1 extra hour.
I'm very sorry.
Yeah, no, I'm fine with that. I can accommodate this. It's the time maybe to jump to the second point. In your opinion, Mr. Reid, and maybe we can ask Mr. Page as well to give us opinion. In my opinion, the CMC points could be the shortest points. I'm intended to deal with them straightforward now before taking break, and then we can break after dealing with the CM's points. Then we come back after the break to deal with the variation of the order. Are you with me in this order?
My Lord, that's fine. I will proceed with the claimant's submissions on the CMC directions. Your Lordship will have seen the draft within the case management bundle. There is a draft case management order, CMO, and that's at page I-17 in the CMC bundle.
I-17?
I-17, Lord, yes. So it should say draft case management order of His Excellence Justice Ali Al-Madhani.
It just disappeared. 1 second. Yes, I see it. It's before me now.
Good. So this is substantially agreed, say where the text is in red.
Yeah.
I should just highlight to the court that the parties have agreed standard disclosure. So that's all documents that are relevant to the issues arising on the pleadings and the list of issues. That broader disclosure is common in fraud claims, not least because parties may not know what the other parties have in terms of documents, but also because fraud often emerges from the peripheral documents. It may be easy to make a small number of documents consistent with the lie that's being told, but it's often harder to make sure that a much wider selection of documents is consistent with a lie that has been told.
Yeah, I see.
And your lordship's experience of fraud cases, it is often some document that initially seems irrelevant that starts to unravel the fraud when it's clear that in cross-examination of a key witness that is inconsistent, that a hard document is inconsistent with something that's been said by the witness in seeking to explain the fraud. I should say that standard disclosure reduces the burden on the court. We all know that the pain of arbitration or IBA style disclosure requests and the extraordinary time that's taken in making and dealing with those requests, whereas in standard disclosure the parties simply get on with it, and the parties are content to shoulder the costs of just getting on with it. So we hope that your lordship will be amenable to making that order for standard disclosure. And we've shown that there is practice, and we've referred to a page in the GFC Court's practice. The case is Veggie Bar, where an order for standard disclosure on that basis was made. The issues on which there is disagreement are the need for an accountancy expert and also the trial date. Part 31, as your lordship will be aware, sets a test of necessity. Is an expert needed? Or in the language of Part 31, is expert evidence should be restricted to what is reasonably required to resolve proceedings. We don't understand why a court would need an accountant to understand the allegations or to consider the allegations of fraud that will proceed to trial as against Prime. Perhaps the starting point is to consider the trading relationship between, or alleged trading relationship between Renish and Prime. And we, as your lordship, have struggled to understand that trading relationship. Mr. Sarge seeks to explain it in what I call the V bundle. I think we've referred right at the beginning to Mr. Sarge's affidavit. It's in the third defendant's application bundle at J56.
You just said J56.
And if I could take your lordship briefly to paragraph 33 at J64. Which I call the V bundle, but it's the third defendant's variation application bundle. So J64.
I found it, yes.
Good. So I'm looking at paragraph 33. This is Mr. Saad, who is said to be essentially running Prime.
Shortly thereafter, yeah.
Shortly thereafter, Prime and Renish developed an extensive commercial relationship in which they cooperated to purchase and sell oil and related products within the international markets. The advantage to Prime of the relationship was that Renish had well-established brand and a network of potential purchasers, 2, a fully manned office in Dubai, 3, sophisticated logistics capabilities, And 4, access to a wide range of local banks' bank accounts in its network of companies in the UAE, such that it could make payments to third parties who could not satisfy the KYC requirements of Prime's banks. B, the advantage of Renish of the relationship was that Prime was able to source and arrange for the export of petroleum products from Iran and Iraq. And 2, Prime was sufficiently well capitalized to do so, to be able to supply Renish with petroleum products on credit. 34, Renish agreed to make payments to third parties on behalf of Prime to offset and or partially discharge the sums it owed to Prime for the supply of petroleum products, third-party payments. The third-party payment system was used extensively by the parties. At all relevant times, Renish kept a full record of the third-party payments, which I reviewed on occasion when I attended Renish's offices. Although the system proved to be a complex structure, at the time it felt both manageable and mutually profitable for both Prime and Renish. For a number of years, I trusted Mr. Mehta and his staff to keep accurate records of the parties' liabilities to each other, and I limited my involvements with the ledger. And then, as set out. 36, I believe that the Renish accounting server and application contained a full record of the third-party payment. And as mentioned above, I occasionally reviewed these when I visited its offices. The accounting server was accessible at the time of Renish's, accessible all the time at Renish's offices. It was being kept safe and updated professionally. As such, it never occurred to me that I might need to keep a copy of this in a different physical place. I shall continue to search my records to find any supported documents reports which may be relevant as the case progresses, so that the third-party payments record can be rebuilt retrospectively. However, this will be a difficult and complex process, so I hope that the contemporaneous records can be obtained from Renish's servers. So essentially what is being said is that the commercial relationship consists of third-party payments by which Renish fronted payments for Prime. So these are payments which would not have satisfied the KYC and regulatory requirements of Prime. So it appears to be essentially an avoidance of the financial regulatory requirements in respect of Prime's banks. And secondly, it allowed Prime to source, because Prime was sourcing products from Iran, it allowed Renish to offer its buyers Iranian produced and Iraqi produced oil products. And again, that must raise significant issues as to, or may raise issues as to sanctions compliance. But most curiously of all, and most relevant for our purposes, Prime kept no records. It was left entirely to Renish to document these, all of that trading, the ledger, if you like, the open account. We say that is entirely implausible as a degree of trust as between any commercial parties. And indeed, even on as to its own bank accounts, Mr. Sadra says that the statements that have been kept are extremely limited. And if one goes back to paragraph 11 in the same witness statement, which is at page J59, one has a number of bank accounts, and in each respect, basically, Mr. Sadra says that he has access to 1 or 2 months of statements. So the Ajman account, paragraph 11, the only statements I've been able to obtain at the present time are those covering the period 3rd of June 2019 to 2nd of September 2019. So a fairly small window of statements. So no documents identifying or evidencing the trading between Prime and Renish. And indeed, even in respect of its own bank accounts, Prime's own bank accounts, Mr. Sarja claims to have very limited access. So what is it that it is said that the expert is going to be doing? Well, if one looks at going back to the main bundle, and one looks at the case management, the third defendant's case management information. Sorry, this is in the the CMC bundle, isn't it? I apologise. So in the CMC bundle at page 3, I don't know if your lordship has that.
Page 3.
Yes. So this is the
I3. Yes.
Of the third defendant. And if one looks at the issue, the accountancy issue, sorry, this is at page I5, top of that page.
Yes.
On what issues may expert evidence be required? A forensic expert, accountancy expert may be required in due course. Well, that fails to identify the issue, which is what the question is, on what issues. It doesn't, the answer doesn't in fact identify any issue. It fails to assert any necessity. The issue is what may be required. And it fails to address the issue of delay, the fact that if one introduces expert evidence at this stage, there may be a significant delay in getting to trial as against the third defendant. Now, you will have seen Mr. Page's skeleton argument, and his suggestion is that in the absence of the ledger, the accountant may be able to explain the transactions. And I don't think your lordship has Mr. Page's skeleton to hand, but if your lordship looks at paragraph 17 of that skeleton, does your lordship have it?
I'm just writing a note, 1 second, yes. Now, what's the page again?
Sorry, Mr. Page's skeleton, page 4, paragraph 17.
I know which bundle I mean, first of all.
Sorry. It'll be in the V bundle.
Yeah, I see.
Well, perhaps I'll read out, my lord, what he says in paragraph 17. The nature.
Give me the reference again. I'm sorry, don't worry.
Don't make the mistake of printing it out. Does Mr. Wheel have the reference for Mr. Page's skeleton argument?
Well, I have visited, I mean, earlier. The problem is that I cannot get access again to the tab B.
It's bundle K. Sorry, it's after bundle letter L.
Yes, that's the authority.
So those are the authorities. Immediately above that.
K, skeleton argument.
Yes.
Yeah.
Sorry, yes. Thank you.
What paragraph you're referring me? I'm sorry.
Sorry, I'm just getting. So I'm looking at paragraph 17, Lord. Does your lordship have it?
Yeah, I do, yes.
Thank you. The nature of Prime's relationship with D1 involved an extended credit line which was discharged on occasion by D1 making payments to third parties. They were third-party payments. The parties kept track of the so-called ledger account by way of a spreadsheet maintained in D1's Dubai offices. The D1's default has meant that the ledger has disappeared. Following disclosure, Prime proposes to engage a forensic accountant to interrogate and explain the financial transactions between the two parties. This complex exercise will enable Prime to make good its defence that the payments received were in consideration of a bona fide trading relationship. C proposes the court makes no decision at this stage about whether such evidence should be granted, but to adopt such a course would be wrong. The CMC is an appropriate occasion to decide the issue. Prime should not be stopped from making good a central part of its defence, namely that the payments to it were legitimate. So in circumstances where Prime no longer has its contractual documentation, what is being suggested is that somehow the accountant will be in a better position to explain the transactions and indeed to offer the opinion that the transactions were legitimate, as described in that skeleton argument. And we say we simply don't understand how it can be said that an accountant can reconstruct unevidenced trading on the basis of partial bank accounts, still less that expert can venture any opinion as to the legitimacy or not of that trading. And we fail to see how that evidence either could help possibly the court, or indeed it could be said that the court needs that evidence. We say it will be clear on the basis of the cash flows. Indeed, it's clear on the evidence the nature of the fraud. If Prime wishes to try and show that these payments, for example, the payments out of the Prime account with NBK, are somehow legitimate, it needs to do that by reference to evidence of legitimate transactions. It can't interpose an accountant to put up an accountant to argue on its behalf that.
Mr. Reid, excuse me, Mr. Reid, are we dealing with this specific point of the CMC as an application, it's or a form of application by the third defendant for appointment of forensic accountants? Is it the way, because there are a lot of consequences will be on this, the way it's decided, then the cost involved, yeah, are we dealing with it as it's an application by the third defendant?
My Lord, no application has been issued. I'm bound to say that we have not objected to the absence of an application notice, and we're prepared to be business in a CMC getting on with it. But that doesn't just stop the court. If the court has its own concerns about sort of informal applications being made at CMCs, that's a matter of the court. But I'm not in the place. I'm not able to. I'm not
talking about the formality. I do understand the formality, but usually the way we treated it is that if someone, wish to rely on expert, usually the court deal with it on an application basis. So the parties would put their case, would give the reason why they need to rely on expert. The original situation, the usual course of dealing, that each party prove his case, prove his defense, prove supported by any available documentation, or even witness statement or whatsoever. If he don't want to follow the natural way of conducting trials, then expert is not the usual way, and then usually they would come and apply. The application can take a different form, can be oral in a hearing, can be in a form of discussion through case management conference, and then that application mean a request. I'm not trying to use a simple language. You either request, you either apply. Sometimes there are. See, this is one of the difficulties, because what I'm saying, if I reject the D3, let's say request for appointment of forensic accountant, whether it would be open again for them to put it in another formal application, or would be a matter that has been decided already. You got my point. So I think at the end of the day, it might look like it's the same things. It can be a request, can be application, so this can be dealt with in a certain form.
I can see that from the perspective of the court, there is greater clarity if a request for application is made formally, whether it's a CMC or otherwise, not least because of the problem to which your Lordship has adverted, which is that if the party then remakes an application, it needs to show that there's been a material change of circumstance. So it needs to be clear whether another party has or has not made an application or a request for expert evidence. I mean, I'm bound to say that it seems to be clear on Mr. Page's skeleton that he is making that request or that application, and he's doing so at a CMC. So, as I say, I wouldn't wish to take a technical point, but the court has its own interests, both as to clarity and as to application fees, in enforcing formality where that's appropriate.
That means you just both agreed that to avoid the court receiving fees for the application. That's why I can accommodate this. That's why
the court's entitled to take its own view and isn't bound by any.
I know you wanted to rely on the court's power on case management instead of filing formal application with an upfront fees payment.
So, just to finish on experts, we say even if there were any basis on which an accountant could help, it's premature. We would only be in a position to know that after disclosure, when we have a full documentation. We say we are very concerned, not least given the application the further application to extend the trial date, that this is all about delay. We don't really understand that, because in the case management order, there's provision for the experts to report, or proposed provision for experts to report by the 20th of January, which would still allow a trial in February, and certainly wouldn't require any delay until May or June, as is sought by the third defendant. But we say it's premature, it's entirely unnecessary, and it's unclear precisely what it is said that an accountant is going to be doing in seeking to reconstruct the trading activities, still less what he would be doing in seeking to validate or legitimize that trading in circumstances where the D3 claims that it can't validate or legitimize its own trade. The second issue I'll deal with hopefully more briefly, which is the trial date. To understand this, one needs to look in the CMC bundle at page I-23, which is an email exchange.
Mm-hmm.
And as with these email chains, one starts at the bottom. So this is Mr. Clark of Defendants for the Claimant on the 1st of September. Does your Lordship have that at the bottom of page I-23?
Give me a second. I-23, the email.
Yeah. So the claimant say, here's a revised draft CMC order. Following receipt of our council's dates to avoid, it appears the only mutually convenient trial date is the 7th of February 2021. So as at that date, when the parties have given their council's dates of non-availability or dates to avoid DTA, the only trial date that works for both parties is mutually convenient is the 7th of February. However, if one goes up, one then sees an email from Ms. Massingham of Eversheds for the third defendant.
Yeah.
It deals first with the provision of an expert, but the last paragraph of her email at the top of page I-23 says, this would mean trial dates in February will not, and referring to an expert, will not be viable, but perhaps you can revert with your thoughts and we can seek to agree suitable dates. So the suggestion here is that if we have experts, we will need to push back the trial date. That is rejected by Denton's, and you'll see Mr. Clark's email, still the 1st of September, top of page I-22, to Dear Eversheds, second paragraph. However, if expert evidence is to be permitted, there is no reason for the forensic accounts to delay starting work should they be instructed, and we consider there to be ample room in the timetable for the 7th of February trial date can be maintained. And then one gets Ms. Massingham's thoughts on that at the bottom of page I-21. Does your Lordship have that?
Yes.
So many thanks. We will digest and revert. However, our immediate thoughts are that a trial date in February is unrealistic. May, June might be more appropriate. So again, the suggestion here is if we have experts, it's not realistic to have a trial until May or June. So all done by reference to expert evidence. And then however, by the 2nd of September, so the following day, the position has changed somewhat. So if one goes to the top of page I-20,
yes.
Dear Denton and Co., second paragraph, on the revised order, we can proceed on the basis say for the hearing date. Unfortunately, our counsel will struggle with the 7th of February due to hearing that is in his diary prior to this. We appreciate this date was put to you as available, but after further discussion, it doesn't look viable. Counsel prefers May or June. So essentially, the tack has changed here. Initially, it was said that it is all rather unrealistic to expect to deal with experts and get to trial by February, and that May, June was preferred on the basis of being realistic. Now it's suggested that counsel will struggle. It's not suggested that counsel can't do it. The suggestion is that Mr. Page will have possibly back-to-back hearings and that he will struggle with that. And he would prefer, as we all do, no doubt, to avoid those sort of back-to-back hearings, and he would prefer instead May and June, which is better, in which he's better placed in terms of his diary. He's clearly very busy. Now, those are not bases to vacate or return, push back a trial. If if there are no experts, then February is clearly viable. Even if there are to be experts, when one looks at the draft CMO, the expert evidence could be dealt with in January, and the trial could proceed in February. We do make the broader points that these proceedings began in 2018. We're now 2 years into this case. This court has been very proud of its ability to move proceedings on its docket control. And for a trial to be pushed into the summer of 2021, 3 years after the start of proceedings, it is in our submission very serious. Serious not only because the costs of litigation inevitably increase when proceedings are extended, but also because we are dealing with a case where there is a very real risk of dissipation, that when the claimant gets judgment against the third defendant, there will be no assets to satisfy that judgment. That risk of dissipation inevitably increases as trial is pushed back. And for those reasons, we say that the court should be robust in requiring that this matter go to trial in February, on the 7th of February, when both counsel are.
Well, I don't know, Mr. Reid, I would refer to this letter of Mr. Messingham of the 2nd of September to Denton, when they said May or June is the only good time for them. Is that because I think they mentioned the availability of their counsel?
Well, they've said at the outset that counsel is available. What they say is counsel will struggle with the 7th of February due to a hearing that's in his diary prior to this. So he has something in his diary prior to the 7th, which would interrupt, for example, his preparation for the trial.
I'll refer to you, Mr. Page. I mean, I'm just going to try to say, so you think this can be accommodated after even the 7th of February?
Well, that's what, in terms of counsel availability, we are told that counsel is available. We are told that counsel has something before the 7th of February, and that on that basis, which is understandable from his personal perspective, but it's on that basis he would prefer that the trial happen in May or June. That works better in terms of his diary. But we say that isn't the basis on which the court should operate. The court lists according to availability. All of us professionally, have periods where we're struggling because we have hearings that are in close proximity, one after the other. But that's just part of this job that we all do. And in our submission, it's not a reason for pushing the trial back by some months to May, indeed more, 3 or 4 months to May or June. We say, in view of the risk of dissipation, in view of the likely increase in costs, this matter should proceed speedily and robustly to trial in February, as it can, as reflected in the otherwise agreed case management order.
Well, see, I mean, in favor of, having agreeable, timing for trial, and before I revert back to you again, if we put 7th of February aside, would you be available? I mean, in the rest of February?
Well, I can't say in the rest of February, but I can say that because we see the email discussion, that the only date that both counsel can do is 3 or 4 days from the 7th of February.
Okay, so what you're seeking is that order by the court. Is this case should be heard on February, and that's it. And then you go agree between among us that the possible week.
Well, can we look at the draft CMO, which is at I-17?
Mm-hmm. I-17.
We've looked at it already, but it's the draft case management order that both parties have put before the court, with the red ink, if you like, showing the disagreement, and the black ink showing what's agreed. And so, if one looks at the red ink in red ink, paragraphs 6, 7, and 8,
mm-hmm.
This is the provision sought by the third defendant for expert evidence, and it provides for exchange reports on the 6th of January, expert reports in response on the 20th of January. So even if contrary to our submissions, experts were found to be necessary to the court. That could be done and dusted by the 20th of January. And there is no reason, therefore, why it should not go to trial on the 7th of February, which both parties have agreed their counsel are available, even if they prefer not to, but they are available to attend. And one sees there at 19, the parties have left blank the date in 2021. They've agreed the time estimate, and they have agreed in correspondence that both counsel are available on the 7th of February.
Yeah, I see. You said they won't be reasonable, I mean, to push the dates to May or June. You say even with a complex, I mean, case management such like this, where expert evidence allowed and exchanged, so the 7th of February would still be ideal and reasonable, and nothing. Being pushing it for 3-4 months extra would be completely unproportionate, in your opinion, Mr. Reid. Is that right?
I just say that the court, if counsel are available, should be in a fraud case which has already been ongoing for 2 years, in which the third defendant, we say, only engaged very late in the process, but has had no inconvenience in terms of pleading and evidencing the case. This court should, these proceedings, as against the third defendant, on the single issue of whether the third defendant was involved in the fraud perpetrated by D1 and D2, that this matter can be brought to trial in February. That much is evident from the agreed directions, and indeed even from the proposed directions for experts. The only issue, the only reason it's said that it needs to be pushed back to May or June is because counsel for D3 would prefer that it be pushed back, because it will be a struggle for him otherwise in February to deal with another matter before the 7th of February, and then to have this trial on the 7th of February. Well, I entirely understand the difficulties of counsel. We've all been in that position, but that is not a reason for delay, not least in circumstances where we suspect D3 has strong reasons for wanting a delay, not least if it provides an opportunity for the dissipation of assets, and indeed delaying any judgment may be entered at the end of that trial. And in those circumstances, given the nature of the claim, we say that a robust set of directions, moving matters on to trial as soon as possible, is the right direction, is the right listing for the court to make. And there's no reason offered other than counsel's preference for moving it to May or June. So in those circumstances, we say the application for a later delayed trial date should be rejected.
Understood. Thank you very much, Mr. Reid. For this, I would turn now into Mr. Page, so he would tell us why he wants to rely on forensic experts, and then why the date of trial should be pushed back to June. Mr. Page?
Well, yes, I think it probably is sensible for me to address it in those stages. And just before I do, it may be useful if if the court is able to indicate, first of all, whether it can accommodate a trial on the 7th of February, because that seems to me to be a prerequisite question to any debate about whether or not the parties can or can't make that week of trial.
The answer is yes.
And the answer is yes to that. I see. Okay. So, my lord, in terms of the expert evidence issue, the relationship between Renish and Prime is that of two commercial counterparties that have been dealing his submissions has taken what we've said about fraudulent conduct and unwittingly or not, it elided two different acts of misconduct by Renish. Certainly, from our perspective, the documents that Renish has produced to SBM, which Renish stated allegedly were created by Prime,
Are you still there, Mr. Page? I lost you for a couple of seconds. Hello, Mr. Page? Mr. Reed?
I'm still here. His Wi-Fi may have needed to redial in, my lord.
Okay, we shall wait for him. Alia or Ayman, can any of you, dial him so he can just take the call as an answer or response to our dialing?
I've just emailed him, my lord. So
Lovely.
my lord, I wonder whether it's worth breaking for lunch at this, or having our break at this point, so that we don't waste court time and Mr. Page can re-establish his Wi-Fi connection.
Yeah, personally, I didn't mind. Maybe we need to communicate the fact that we are having a break to him as well, instead of he keep trying to call us. Okay, see, until someone communicate with him, either you or the court, that
We will resume in 15 minutes at 10:30 UK time, 1:30 Dubai time. Sorry, 12:30, 1:30 Dubai time.
no, actually, it can be longer than that. We come back by 2 o'clock. We'll take 45 minutes break.
My lord, yes. I will email Mr. Page to that effect.
And listen, Ayman, are you there?
I am, yes, Judge Ali. Ali is contacting him now as well, so...
Well, Ayman, would you please communicate to him? So we prefer that we will take a 45-minute break. We will resume at 2 p.m. Dubai time.
Okay, of course.
Okay, so then we will start with Mr. Page, defending the idea of that he's intent to write an expert, and then to discuss the possible trial date.
Okay, okay.
This is a jerk. Thank you.
To stay this time.
Oh yeah, good to have you back, Mr. Page. Yeah. We sorry we lost your connection with you earlier. Then we decided, actually Mr. Reed anticipated that your coming back would take more than intended, so he suggested that we should take a break, and I think that was a very wise recommendation.
Yes, certainly. I think it's probably the first time and last time of this hearing I'll agree in full with Mr. Reed.
Yeah, I think we stopped where is your turn to tell us about your position in regard to the expert and then the trial date.
Yes, so and perhaps if I start first of all with just responding to a procedural point you raised about whether or not this is, properly speaking, an application, and whether or not my client, properly speaking, should be paying an application fee to the court.
Yeah.
I confess that on our side, we had never considered that it may be deemed to be an application as opposed to a case management matter properly resolvable within the confines of the CMC. Mm-hmm. But if the court considers it is appropriate to treat it as an application, and it is appropriate for us to pay an application fee, then of course we are perfectly content to have that as a condition of being granted relief or being required to pay it. And certainly I should make very clear that we are not at any point trying to play procedural games here or minimise the sums which are properly payable to the DIFC registry.
Sure.
Turning on to the expert issue in principle, I hope you heard the start of what I was saying earlier, which was that the relationship between Renish and Prime goes back a large number of years. It is an entirely legitimate commercial relationship of very long standing. The way in which the relationship evolved was such that Renish provided back office support to Prime and kept this ledger that will be the focus at trial very much in terms of the money flows between the parties and how much was owed by whom, and our entitlement to receive payments from Renish.
Does that mean you understand the position of why Renish have done this with the claimant?
Well, so what it means is that we are ourselves in the same position as the claimant. And in a parallel world, rather than being the object of attack and accusations by the claimant, frankly, it would be a far more sensible approach for the two parties to join hands and jointly pursue Renish. We are pursuing Renish in other jurisdictions, and there are ongoing steps being taken by Prime against Renish. We are owed approximately 53 million dirhams by Renish.
I see.
That has all been ongoing since the summer of 2018, and the discovery of the claim against us only arose much later, and it arose as a result of the as ever that there are relatively few JJC decisions, and when the JJC decision was handed down, that had some publicity that then generated a digital footprint about Prime that someone alerted to Mr. Sada. And it was through that course of events that suddenly Prime discovered it was the defendant in proceedings and alongside Renish, and that sometime later, when it Prime being unfamiliar with the DIFC's procedures, it instructed lawyers, it got access to the online court file, and it found out the terms of the precise claim being alleged against it, and in terms of the WFO. So you have a bit of a lag there between August 2019 and October 2019 for the date of full discovery by us in terms of what has been going on in the background by SBM. So all of this in many ways comes back to the ledger, and that is flagged up by your very perceptive comment and question to Mr. Reid right at the outset of this hearing, where you were saying that in reviewing the papers in advance of the hearing, you were seeing that there were some money flows both ways between Renish and Prime, and you're trying to understand that.
Yes.
Now, Mr. Reid seeks to characterise those payments, and will continue to do so up to and including at trial, as evidencing fraud and a conspiracy between the parties. In fact, they do the very opposite of that, and those payments and counterpayments can be seen exactly in line with the very same transactions that happened between SBM and Renish. So again, with SBM and Renish, you have some advances being made, then you have some payments back being made by Renish, which then generated further substantial advances by SBM. And that, broadly speaking, is what we have between Prime and Renish as well, that we extended a credit line to Renish. That credit line indeed was greater overall than the credit line offered by SBM to Renish. And at certain strategic points, Mr. Sada communicated to Mr. Mehta saying, you need to make payments to us, and we're not going to give you any further credit until you have made payments to us. Lo and behold, some payments would come in, and we would then provide further credit. So the payments flowing backwards and each way and this way,
the classic financial
generate and provide evidence of the course of misconduct by Renish against both SBM and Prime. Now, the role for a forensic accountant in putting together that exercise is as follows. The ledger, the hard copy, full, complete, comprehensive ledger was kept by Renish and was made available to Mr. Sadder. It's understandable entirely that ledger was not maintained by Prime independently, because those very same back office operations were indeed being carried out by Renish. So they put together the ledger, and it was open to audit by my clients. And then you have fairly common, but nonetheless relatively complex, given the time period involved, flows of oil cargoes and flows of money, both between the two principal named parties here of Renish and Prime, and between associated companies with Renish, such as Petrochem, and indeed there are others as well. And then you have these further third-party payments by Renish to Prime's creditors. And each of those strands can and will be evidence in due course and come out in disclosure. But it's a process of effectively a backwards building audit trail. So one is going to be left at the end of disclosure with all the underlying raw documents, and then putting those back into a form that is comprehensible to the court. It is not an appropriate question for lay witnesses, and the court would be ill-served indeed if the lay witnesses or the lawyers were to attempt to carry out that process without the assistance of accountants. Whereas accountants can do this and do this as part of their day-to-day work, and can compile matters relatively quickly and cost efficiently. And indeed, it's the use then of forensic accountants that will enable us to come on to trial far more quickly than otherwise. Mr. Reed's objection, in some ways, we don't understand it, because on SBM's case, there has been a fraud and a conspiracy, and we simply cannot put together the ledger, and we can't explain the underlying documents. Well, if that's their case, then they shouldn't be afraid of us attempting to do so, because they should be confident that it all comes to naught. We say that it is fair, right and proper that we are given an opportunity to put our defence forward. Very serious allegations being made against Prime for a very significant sum of money, and it simply would not be fair for us to be denied an opportunity to make good points in our defence. And I'll perhaps just explain that very briefly. If Your Lordship, you have a look at the defence, which I'm looking at the version of in the CMC bundle, which starts at page G32.
G32. Yes, that's D5, I guess, yes.
And then if you turn on through to internal page 9, which for me is G40.
Yes. Bara 18.
Paragraph 18, yes. And you'll see there at paragraph 18 the description of the first cargo and the related trades involved in that, and each of those parts of that trade themselves generate underlying paperwork, and indeed flow of money to third parties as well. And we'll see there that the first cargo in early February amounts to $12.2 million in round numbers. The second cargo, about a month later, on 7th of March, in round numbers, results in $13.6 million worth of oil being supplied to Renish. The third cargo is about a week later, 16th of March, and results in $14.1 million being provided by Prime to Renish. And the fourth cargo is a month later, on the 16th of April, and results in nearly $15 million of oil cargo being provided by Prime to Renish. So the aggregate amount of those payments, taken in isolation, more than covers the sums in issue in this claim. But what we don't have here is a straightforward series of 4 payments directly matching the sums which were charged by Prime for those 4 cargoes, and it's that that gap between the two that we accept does call for explanation, and we accept does require reasonably the court to examine the wider relationship between the two parties, and we recognise and we are perfectly prepared to meet the challenge made by Mr. Reid, but it is only really ever when the court has an opportunity to look at the wider scope of documents in a case such as this, that it is able to form a clearer view about the whether or not the relationship between two defendants was a bona fide legitimate trading relationship, or whether in fact they were conspirators. We do not shy.
Hang on, Mr. Page here. Hang on here, Mr. Page. There is I have 2 questions. First,
yeah.
The first question is that what appears to me from this described transaction, that you're always the product or the service provider to a Prime, and Prime is the party that's to pay you the money, so you're the money receiver, according to this, and even according to the contract between Renish and SPM. So you always the oil provider and the money collector. So this is, I mean, for me, still in conflict with the why on earth you appear in some other accounts you're the paying party to Renish. That's the first question. The second question is that the work as the forensic expert is not to explain or to give a legitimate reason to certain transaction. This is a matter of evidence. If you have this even either accounts, transfer, or any kind of financial document that you present it to the court, you say what it means, your opponent has it say what it means for them, and the court would interpret what that evidence means. I don't think it's not a very technical. We're not asking the forensic accountant just to tell us how much money. It's not about how much money at this stage. It's what it means. What kind of relationship between you and Prime? Yes, that you can establish it. The court can read this from the document. You can read. Your opponent could read. With the 3 of us could have look at this document and define the relationship between Prime and Renish. We could even quantify the numbers, even if it goes to hundreds of millions. Why not, I say? They're going to be, I'm sure, agreed matter of facts and disagreed matter of facts. But the disagreed matter of facts would need court intervention. The court with parties would draw analysis to all of this document that you have produced and you're going to produce, and will apply them to the fact and see what's inference the court will draw from them. It's really, yeah, you gotta really tell me, because if you look at how experts works and what kind of opinion you're expecting from forensic accounts to tell a court about a figure or a document, is something like, I would say, every junior lawyer would tell. They have a scope, and the scope must be precise. And what I'm hearing from you now is this: the forensic accountant can plead your case in different way, can help you present your innocent situation, can do a lot of things. He can also analyze the documents. He could justify and legitimize the course of action. But I don't think, in fact, that is the work of forensic accounts, Mr. Page. So I think you need to give us much clear picture and reasonable, legal clear picture, and what would be the role of the forensic expert in this level. Go on.
So, just responding to your 2 points there. The first is, you are right that in the 4 cargoes, we are the supplier of oil. But as I'm indicating, the relationship is wider than that, and in fact, on occasions, Renish provided cargoes of oil to Prime, and companies associated with Renish provided cargoes of oil to Prime. And PetroHub is one example that percolates to the top of the papers from the disclosure that's been provided to date. Mm-hmm. So you do have cargoes of oil being provided by either party, and you therefore also have money flows going from either parties, and whether or not those are money flows that are completely offset by each other, or whether you have they go partially against credit lines, are matters of detail that change according to a particular transaction, and we can't really get into the detail of that until we know we're through disclosure and we have witness statements. On the question of the accountants, I say that the benefit to the court comes in a number of different ways. The first is that we're putting this case down for a 3 or 4 day trial. Now, necessarily, for a trial of that length, it is not possible to interrogate and build up a very detailed picture of documents using the raw data. The court, if the court was simply relying on witness statements for that and the efforts of counsel, the court is going to end up with very lengthy witness statements of fact, a lot of cross-examination, and I doubt, despite Mr. Reedon's and I's best efforts, you're going to end up with spreadsheets that are littered with errors and poor practices that the counsel would roll his eyes at. An accountant can cut through that and will be able to identify the core points. I am not suggesting that an expert accountant will in any way fetter the court's ability to make findings of fact at the conclusion of the case. What the accountant will be able to do is the accountant will be able to assist the court, to whom it will owe, he or she will owe his or her primary duty, to say that having gone through the relevant items and having cross-referred them to the raw hard copy documents, and pausing there with disclosure, at the moment the timetable is largely premised on the parties being content with electronic disclosure. But if one has hard copy disclosure and an inspection of hard copy documents, the current timetable will become much more difficult very quickly. But an accountant can go through all those documents and can then provide comment as to whether or not the what the ledger was, and whether or not the money flows between the large number of bank accounts correspond to that. Now, one is talking about, I don't have the exact number in front of me, but I think it's about 9 or 10 different bank accounts. One is talking about very large flows of money. All of that will then need to be cross-checked with relevant emails and with relevant WhatsApp messages and a whole series of other pieces of documents. That is a technical exercise. It is an evidence-based exercise, and of course it's an exercise that the court will ultimately get involved in at a certain level of abstraction, and about which there'll be a certain level of cross-examination and submissions at trial. But what the accountants can do is help the parties focus their efforts on what the key points between the parties are. And indeed, if both parties appoint expert accountants, and the accountants are in broad agreement as to the money flows, then the court will be assisted by that. If indeed they aren't, well, they're not, and we're largely back where we are. But it does come back to the point that we have on our side we've been effectively set the challenge by the claimant to say, prove that our relationships with Renish were legitimate. As much as we would like to say it's very simple, here are the 3 or 4 transactions which simply answer the point, we recognise that would be an overly narrow answer to the claim, and that in fact it's appropriate for the court to take a wider view. Obviously,
so Mr. Page, Mr. Page, if I understand you correctly, and correct me if I'm wrong, is that the expert would be assessing the court, and reviewing huge or mass production of documents, and provide certain comment on the type of transaction, the type of where the money going, and maybe the reason was given. But then you said at the end, and the court would have the final saying. What does that mean? Not the expert. So the problem is that, in your opinion, they're going to be a huge number of documents. So the accountant would help the court to cut them short, to focus on the more important things, and to give the court the ability to comment and fairly reasonably a number of documents refer to certain transaction to find its way, whether they were fraud or not. What I'm saying, the course of dealing between Renish and SPM, which involve your client, is only in a matter of almost 6 months. It's not a huge period. The so far given fact, there were no much of business your company been doing through even during that time. So can I say that is giving me indication they shouldn't be the number of documents that you're anticipating, thousands of millions. And even the difficulty that most of the document with Renish, that might be another issue that would cut the number of documents, because Renish has vanished. So we might not be able to get into that kind of document. Even your evidence says you don't have much document in your custody. So this is what again lets me go. You said, then what's the need of the accountant? If you say it's his role to help the court because a huge number of documents, then your evidence says there is no much document. There is no that huge thousands of documents during this course of dealing. So I think you owed me a better explanation, Mr. Page.
Well, my lord, the answer in terms of the volume of documents it is that over the past week, and largely since the case management information sheet was initially completed, some further work has been done by Mr. Sada and by others on behalf of Prime to try to isolate exactly what volume of documents it is we're talking about. We do think it's going to be a relatively large quantity of documents. I suspect it'll be approaching it'll be the high tens or the low hundreds of thousands of documents. Mm-hmm. We say that the expert will provide a role that is helpful. And the difficulty is that there are basically 3 options open to the court. One is grant me permission now. 2 is adopt a wait and see approach and say, well, let's have a look at disclosure and then let's all come back in mid-October, late November, and have a discussion once we've actually seen the documents and we've worked out really what it is the late witnesses can and can't say on the basis of those. Or thirdly, refuse the application outright now. Now, obviously, I'm asking you not to take option 3. The difficulty with option 2 is that the court is able to accommodate the parties in February for a trial. We are not seeking to delay the trial at all, and if the court is minded to set the case down for trial in February, and I'll go on to explain some difficulties with that, but these are personal difficulties, and of course I'll bend to the court's will on that point. Then we will press the make it fit button. But what that means is that if we can't take any steps in relation to a forensic accountant now, we have to wait until mid-November before revisiting the point, then suddenly we've only got a couple of months until we're into trial. And at that point, Mr. Reid, quite sensibly, could say, well, this is all far too late. We'll be heavily prejudiced. The trial date is set down, and it'd be unfair to let in evidence so late. So we say the appropriate junction point to make decision is now, and the proposal I made in my skeleton to the court was that the court can effectively put its toe in the water on this grounds. It can grant me permission to provide an expert report. It doesn't need to provide permission at this stage for experts to give oral evidence at trial. And then in due course, we can come back. We can grant liberty to the defendant to prepare an expert report, but that will be after we have prepared our report. So we prepare our report. The defendants can then have a look at it. The claimants can have a look at it. If SBM forms a view that it's a pointless document that doesn't help us at all and is irrelevant, well, SBM then won't go off and get their own expert, and the court will just have our report and we'll be told in due course at trial why it's irrelevant. But if it is helpful, well, the court should get on and allow us to put that together now, and to be able to defend ourselves properly on a case where over $30 million is being sought from us.
Mm-hmm.
So, my lord, those are my points on the expert reports. Unless you have any further questions, so I'd go on briefly to talk about the trial date question.
Well, what I do see the connection between both points. I mean, if there is if the courts completely reject the idea of forensic accountant expert, then the time needed for the preparation should be sufficient. If the expert granted from now, so even that time, the time frame can be met or can be accommodated. So the risk of jeopardizing the trial date would be very, very, very small. The only point which is the option 2 you were saying, that the courts wait until the production of documents and then reassess the situation and hear back from you and from the claimant and see whether the accountant is needed or not. I think, yeah, so this is the only point that might really need to.
Well,
let's hear from Mr. Reid. I mean, what he says. Yeah.
Well, can I just suggest a route forward as follows then? That you grant me permission now to provide an expert report, mm-hmm. And we do it as sequential exchange, and so and I'm sure our solicitors will agree on the appropriate date for SBM to write its report, mm-hmm. And there'll be a sensible gap between those. If upon receipt of our expert report, the claimant reaches a view that it's not really an expert report, it's inappropriate and improper in some other ways, then at that point, they can not only choose not to appoint their own expert, but they can make an application to strike out our expert evidence on the basis that it isn't really expert evidence. So that then means that the default is flipped over, and the default is we're allowed to run our defence properly and as we see appropriate and as we see it is necessary with forensic accountants. But if SBM has strongly held views to the contrary, well, it can come back to court in November and December before it is put to the expense of preparing its own expert evidence and explain why it is that evidence should be disallowed.
Well, I can guarantee you, Mr. Reid would come in anyway, would come and say, they strike out this expert without you giving him that emotion, Mr. Beach. Let's hear from Mr. Reid.
This is a bizarre suggestion. As your Lordship has said, they are relying on a very small number of what they allege to be proper transactions relating to a number of cargo. First cargo, second cargo, third cargo, fourth cargo. So they are saying, insofar as monies are passing backwards and forwards, each way or this way, as they say, between prime accounts and D1's accounts, that they can explain those transactions, those payments out of the prime account of prime by reference to other transactions, indeed 5 transactions. Now that ought not to be difficult. If on the disclosure they have all of the documentation relating to those transactions which they have been involved in setting up, why does the court need an accountant in those purposes, to explain documents relating to those transactions? It is, as your Lordship said, it is a matter for D3, for Prime, to come to court and say, well, look, that payment that we made out of the Prime account to Renish can be explained by reference to this oil transaction. Here is some contractual documentation. Here are some WhatsApps relating to that cargo of oil. And we say that's a legitimate transaction. Now, I can well see if, for example, there are issues about sanctions compliance, why Prime might prefer that an accountant comes to court and says, well, look, I've looked through all these transactions, I've looked through the underlying documentation, and I confirm that this is a legitimate transaction. That, in my submission, does not assist the court at all. The court has still got to look at the underlying documentation. If there are core documents that are relevant, that is within the job of counsel to identify that document, to build the narrative in terms of the witness evidence, and to build the explanation in terms of the submissions to assist the court. The court ultimately is going to have to make a finding on the D3's case as to the legitimacy of those transactions. And that legitimacy can only be established by reference to documents showing ordinary commercial activity and by the cross-examination of witnesses as to that ordinary commercial activity. There simply isn't a shortcut by bringing an expert along who somehow sort of puts up his hand and says, yes, I've audited, to use my learned friend's words, I've audited those transactions and it all seems fair and above board and legitimate to me. As for the suggestion that somehow introducing expert evidence is cost-effective or time-effective, I have yet to see in my long career a case in which the involvement of accountants has rendered matters cheaper or indeed has significantly simplified the approach to evidence. The court is still going to have to look at, identify, consider, and make decisions based on actual documents, not based on some glib conclusion from an expert accountant.
Giving the nature of each case,
and so my learned friend drops back on this sort of midway house that, well, as long as if we have permission, if D3 wants to engage for its own purposes an accountant or a bookkeeper or any other manner of professional, unfortunate professional, to go through all of the documents that come up disclosure in respect of the alleged legitimate transaction, that's a matter for its own accountant or bookkeeper or whatever can identify the relevant transactions and the relevant payments and the relevant documents explaining those payments. But the idea that one side gets permission and that it's then incumbent on us, with the court having sort of had a try, sucked it and seen as to whether this one-sided unilateral expert approach applies. If there were to be expert evidence, it would obviously be sequential. So there's no concession in saying that this unilateral procedure should proceed sequentially. Either this court says now that the parties have permission for experts, and that the court needs, and that is the test, needs the assistance of expert accountants in order to understand the evidence as to the legality and legitimacy of various alleged transactions, or it doesn't. And we say at this time there is no evidence that the court needs, or no sustainable submission that the court needs that expert assistance. If the case is properly evidenced, if the case is properly presented, then the legitimacy, or we would say otherwise, of those transactions will be clear on the evidence. And we are deeply concerned that the attempt to engage experts and the attempt to interpose new stages in the procedure is a part of an attempt to delay the trial and to push off what we say is inevitable, and that's to say judgment against Prime. So we say the middle position, or the compromise, basically one party having permission for an expert to see, in my learned friend's words, if it is helpful, is not a procedure which has been to date adopted or pursued by this court, and is not a procedure that should be adopted by the court. Either an expert is necessary or it isn't, and we say there's strong evidence that it isn't. I do just wish to say, in respect of the continuing assertions of legitimacy, there are further assertions that cases or claims have been brought in other jurisdictions. I'm sure many of us on the claimant side were waiting with bated breath if there was going to be any suggestion of a particular jurisdiction in which proceedings have been brought. Obviously, if a particular jurisdiction were named, we could then go to the court file and see what is being said in the other jurisdictions. But thus far, everything that has been said about the alleged claims in respect of the 53 million has been incredibly vague. So they say in their defence, for example, at paragraph 52.4, proceedings were brought in 2019. That's a year after they say they discovered the fraud in July 2018. They say now that proceedings have been brought in other jurisdictions, as yet entirely unidentified. And they say too that the relationship was so trusting and so legitimate, built over several years, that they had no idea of the documents. The documents were entirely kept by Renish. And yet, we actually have quite a lot of detail in respect of the supposed cargoes, and we have quite a lot of detail about the 53 million that's said to be outstanding. There's a strong suggestion, we would say, on the basis of that assertion, that in fact Prime did have details of the supposed alleged EMI related trading, which they now claim to be legitimate, and which they now claim to be related to the payments out of the Prime account. If they have that evidence, they should deploy it. If they have the documents, they should disclose them, and then the matter can be properly determined by the court in the ordinary way.
So, what do you say about the proposition that the court must wait until the production of documents are complete and then have another go, so to review the situation? So yeah,
well, I didn't really understand that. If it was proposed that Renish were going to disclose documents, then it might be that the documents that Prime are looking at, the pool of documents is somehow greater, and all of a sudden Prime will be able to better understand its legitimate historic trading with Renish. But what is likely in disclosure is that we, the claimant, will get disclosure of some documents relating to the alleged legitimate trading. But it's hard to see how we, SBM, are going to have any documents in relation to these alleged legitimate transactions. So it's hard to see how the documents actually are going to make it any clearer on disclosure. We say the position is clear now. Prime has its documents. If it can make a case that the court genuinely needs forensic accountancy expertise, then in some sort of audit in the way it proposes, and that would assist the court. But this isn't about an audit. This is about establishing before the court whether certain transactions or cargoes were part of legitimate trading, and that requires all of the usual evidence in terms of commercial and legal documentation relating to what are said to be legitimate transactions. That, my lord, is a matter of evidence. It will be a matter of cross-examination at trial of any witnesses that Prime decides to put up. But it is not a matter of an expert standing up in front of the court and purporting to save the court's time by venturing an opinion as to whether these transactions are legitimate or not.
Yes, I see your point. Yeah. Mr. Beach?
My lord, yes.
This is the last go on this matter, yes.
Yes. In terms of the other court and other jurisdiction, the answer to that is it's local onshore courts in Dubai. There is, and it's a claim against the National Bank of Fujairah, who took money out of Prime's account to pay sums that it said were owed to it by Renish. We are challenging that, and that is ongoing, and that's our claim against that bank in those in that jurisdiction.
But that doesn't involve Renish, isn't it? Renish is not your counterparty in that case.
So correct, we're going after the bank. We're taking a somewhat more focused approach.
We're actually
looking at where the money is.
Well, Mr. Rage, I can't tell what Mr. Reed can tell next. Maybe this is another conspiracy by you and Renish against that bank. So, but you need to refer to a case against Renish, not another bank or anything. You can't have cases against anyone.
Well, perhaps, my lord, in due course, the court file is available anyway, members of the public to have a look at, and we'll be disclosing documents relevant to that court, and the court will see the positive steps we were taking before we knew anything about this litigation. Well, we were making very clear allegations about what had happened to us as a result of Renish's misconduct. And sworn statements made to the onshore Dubai courts relating to those, and they're entirely consistent with our case that we ourselves here are properly speaking the victims of misconduct, and in no way a conspirator of any misconduct with Renish, and I'm afraid it simply isn't appropriate just because we're pursuing another party. That is itself suggestive of ongoing other conspiracies.
Well, Mr. Bate, believe me, I have seen a proceeding, and this is official statement by me. We have seen a proceeding, a fake proceeding, initiated in a certain court, and we having a defendant that's maybe admits the case just in order to make a money laundering money sent out from faraway jurisdiction to the court account, and the court account paid up the money to the claimants, so the money clear. We don't want to go that far. If you have case against Renish, you should say, oh, Renish have done, this is the cause of action, this is what Renish has done, this is what to prove our money against Renish. That's what usually happens. I mean, when you say, oh, we involve another bank, but Renish is the guilty party in that.
I should be clear. We are the claimant in that other proceedings.
I understand that. Yeah, I understand that. I said
we're not the defendant.
Why Renish is?
Yes, I'm aware of so-called laundromat cases, and there's been a whole issue with them in arbitration awards, but that has nothing to do with what's going on in this case. And indeed, that argument might be raised against us if indeed we were in litigation against Renish. And I've said what I have to say about that. Mr. Reed challenged me to clarify what litigation is we're talking about, and I've stated it can be and openly, and it's now for SPM to go off and have a look into that. I think there's probably been enough tit for tat in terms of the expert reports. I've suggested what I say is a perfectly sensible midway path between the two, and indeed my path has more of a sensible eye on the proposed trial date of February, which we would like to accommodate if possible. The idea that we are looking to delay matters or overcomplicate them is simply not true. We provided dates to avoid for trial that ran through a lot of February. My personal trial diary it sounds like, as with Mr. Reed, just creates problems for our respective clients because we have other professional commitments going on. In terms of the trial date, I'm in trial immediately the week before, the week of 7th of February. So my preference, and indeed my clerks shouldn't have been offering a trial immediately.
Excuse me, what date is that and how long?
Pardon me?
What date is your trial start? The week before? The first week of February, you said you have a trial. My
Correct.
question, what date and how long?
So I shall tell you exactly.
If you don't mind.
The trial starts on Monday, the 1st of February, and it continues until Thursday, the 4th of February.
Oh, I see.
Then I
Have a
just
weekend.
to provide visibility for the court. I then have a 2-week trial starting on the 1st of March, and that comes to an end on the 11th or 12th of February, and then I have a further 1-week trial on the 22nd of March. So it was for those reasons that no dates were offered in March from our side. April availability is good for us, and then some dates turn up, and May and June there is some availability, albeit not all the time. We have, well, and more importantly than me, Prime is very keen for this case to get on to trial, but also Prime does not, sensibly, does not want to be forced to rush its defence, so that it is in trial before it is properly in a position to be able to defend itself from these very serious allegations. The absence of availability in later in February and in March itself, I understand also it's partly to do with Mr. Reed's diary. If we can find even perhaps 1 week later in February, that would make my life personally much easier. If it's truly not possible to have a trial starting on the 14th of February, well, as indicating earlier, we may just have to simply press the make it fit button. My own request would be that the trial starts on the 9th of February rather than the 7th, because that does at least give me a couple of extra days of preparation before having to barrel out of the previous trial.
Yeah, you just suggested 9. What date is 9? Let me check with you. That will be Tuesday.
Tuesday, yes.
That will give us the 3 clear days before the weekend.
Yes, and so what I'm asking for is give me a permission for my expert report now, so we can go on and get that going and all know where we stand for trial now today, and then we can and should be ready for trial on the 9th of February.
Mr. Reed, what do you think about the trial date?
Well, my lords, you've heard me on experts and why I don't think the supposed compromise really assists in any way. In terms of the timing, the email from my learned friend's solicitors suggests that, in fact, he doesn't have good availability in April, or indeed in May, because they're non-available the 1st to the 21st.
Well, he just said he's available all of February.
Something's come out of his diary. What I can say in respect of the 7th or the 8th,
he said 9.
Well, I'm just going to explain. That is 3 days. I think we are suggesting, and indeed it's been suggested, that there's going to be a lot of documentation. In those circumstances, to be reducing the time estimate for trial from 4 to 3 days, it seems to me unwise, and the risk therefore is that one would then have to come back or resume on the following week, which doesn't work from my perspective. So the 8th would work because the 8th is a Monday, and so one could therefore do Monday, Tuesday, Wednesday, Thursday within the Dubai week, and I certainly have no objection to moving the start from the 8th, which would give Mr. Page an additional day of preparation. I mean, he will have finished his trial on Thursday the 4th, and he will. I mean, we're all used to situations where we have back-to-back trials. There are means of mitigating this in terms of working on the skeleton, in terms of the solicitors getting the trial bundles sorted sooner. And in my submission, if he were to finish his previous trial on Thursday the 4th, to then have a start and another 4-day trial on Monday the 8th, wouldn't be unduly punishing, or to him ought to be something that he can manage. No doubt if he's assisted by his instructing solicitors in that. So we say, and the reality is that if we don't have the trial in that week, I should say Mr. Wheel has a trial starting the 1st of March, going to the 31st of May. So he has a fairly lengthy trial, and indeed, given the risk of overrun, he wouldn't want to confirm his availability until mid-June 2021. So if we miss this opportunity in February, the consequences are pretty significant in terms of matters being pushed off into June. And I should say Mr. Wheel has been heavily involved in working on this case. I have been less involved. So Mr. Wheel's absence or unavailability would be pose a very serious issue for the claimant. So we would be, it's important that he is part of the team, even if he's not the advocate of trial. So in those circumstances, we say happy to push things back to Monday the 8th, far less happy about pushing things to Tuesday the 9th, given the risk of an overrun, or given the risk that we simply can't finish in the relevant week and matters go part heard. And if we can't have that week, then we really are in trouble, because we're really pushing things back into late June of 2021, some 3 years after these proceedings were commenced.
Well, okay, let me put it this way. When we think of 4 days, well, apparently the 4th day would be maybe for the closing submission. Is that right? I mean, more likely. More likely the 4th day is the closing submission. Most of the evidence, opening evidence, can be dealt with in the first 3 days. I think maybe I'm thinking aloud, leaving the closing submission to the first day of the next week. That will give you a maybe better ground to have prepared for a very good closing submission. So I said, why not 9, 10 and 11 for the evidential hearing, and then 12 for the closing submission.
The 12th is a Friday. The 12th is a Friday, my lord. So if your lord's happy to
Oh, so
sit...
sorry, I just say, I mean, yeah, 9, 10, 11, 12, 14th, I mean, 14th for the closing submission. Well, first of all, I don't know if I'm going to be the trial judge, because we need to look at we have a certain docking system. Yeah, it's the preferential is mine because of my knowledge and connect with the case, but it can be someone else. That's one thing, so I can assure you. But I said, this is my question to Mr. Reid, if you can agree that we start on the 9th, 14th for closing submission, we have protected the 4 days trial.
Well, I'm not available on the 14th, my lord. I don't think it's ever been suggested that I was. So
okay, the week after is not. I see.
So if your lordship was willing to sit on the Friday, then that works for me, and I would be content to do that. Speaking for myself, but as I say, I'm away the following Monday.
I see. Okay, let's go back to Mr. Page and ask him about the possibility of making it at 8th of February. Mr. Page.
My lord, I think I'm going to be Mr. Compromised by the end of this hearing. Perhaps the afternoon of the 8th. If we start then, that gives us 3.5 days, and that then should work. And if we have a late finish on one day, well, so be it, if everyone can accommodate that. But that then ought to be sufficient.
So I didn't get you. Excuse me, say it again.
So if on the 8th, we start on the 8th, but only in the afternoon of the 8th, or say not before 12 p.m., then that does just give me that little bit more time to jump from one case to the other.
Yeah, so you would, okay, does that mean the first day would be for the opening and addressing the court and important matters, housekeeping things and opening, and then the evidential burden will be dealt with from the next day?
Broadly speaking, yes.
Yeah, because usually this kind of timetable that the courts do. The first half day is for opening, and then only after lunch the cross-examining starts. Well,
if Mr. Page accepts that it may be necessary to sit late or early on other days to accommodate that additional morning, then I don't think I object to him having a later start on the Monday morning, on the Monday the 8th.
No, I think we either we accept this as the 3.5 days. I mean, it's very difficult. I mean, to conduct hearing in the weekend. It's not about the judge, but it's about the court staff, the registry, the issuings of any necessary orders, and it's, I don't know.
If the order could say starting on the 8th, starting at midday, then that would reflect.
I think, Mr. Reid, if there is, let me put it this way: if this court, for example, sees there is no necessity for to bring an accountant on board, that would save cross-examining of 2 important witnesses. This might make the 3.5 day fairly reasonable. Good timing.
My lord, yes.
Yeah, I guess so. Well, initially, I can tell you, and it's no secret to hide from you. This is my initial thinking is not to allow, experts, because I don't see any real necessity, and given the fact that the role of experts is something not possible to happen with this kind of a transaction. But I still need to have a final finding at this point, to be fair also to Mr. Page. Okay, let me think this way. If there is no expert evidence allowed, then 3.5 days would be fairly sufficient. If an expert allowed, then we will need at least another half day to accommodate this.
My lord, I need to only say that the timetabling concerns should not be a factor in your decision on the expert. Either an expert is needed or they're not. So, insofar as your lordship reaches a conclusion,
no, yeah, the trial day should have no influence on the decision of expert, but it's otherwise. It's only the otherwise. Yes. Okay. If you give me a 15 to 20 minute break, I really need to re-examine this issue with witness and see. I need to go back to read Mr. Bates' submission and this before I can have conclusion within 15 to 20 minutes. So then we can deal with the issue related to the variation of the order.
Yes.
So, yes, Mr. Bates.
Okay, yes, we're very content with that. I'm just conscious that it's now 3 p.m. And the application to vary the freezing order is not an application that can be disposed of in a matter of minutes. I'm given that it's taken us nearly 2 hours or so of argument to resolve 2 paragraphs of an order that's been largely agreed between the parties. I think where there's a real issue of fact and law between us on the variation points, we are now going to seriously struggle to resolve that this afternoon.
So you think the variation point would take more than an hour?
Yes, I think that my submissions on it will take just under an hour.
Okay.
If I understand Mr. Reid's submissions, we are largely 2 ships which pass in the night, because I take a series of legal points about the appropriateness of the exception. Mr. Reid takes a series of factual points about post-freezing order conduct. That's going to need to be knitted together by the court, which is not a straightforward exercise.
So let's say that would take about 2 hours. What's the problem of me having 15 minutes to rethink about and rebalance your application to appoint expert and have an opinion and fix a trial date?
My lord, I should be clear. I've got no problem at all with you taking a break.
It's only 15 minutes. I mean,
my comment only is that
you do want to be shocked by the court order in regard of the expert, or what is that, Mr. B?
No. It's not that. It's whether. But perhaps we should leave the discussion until the end of the expert report phase. But I am wondering whether we are getting close to the point of having to find an alternative date to have the argument about variation of the freezing order. But perhaps Mr. Reid and I can chat about that briefly whilst you are taking your break, my lord. Now, I thought
there is no link between the trial date and the variation of the freezing order.
My lord, from my perspective, I would expect to be about 45 minutes. So if your lordship has 15 minutes now, if we resume at 3:15, then
that's
hopefully
very generous. Yes.
Well, okay, 3:20, and then hopefully we should finish by 5 p.m. Dubai time, if that's all right with your lordship and with the court staff. Then we should be able to resolve matters today without the need for a further hearing.
I think yes. Maybe I can adjourn the issue of the fixing the trial date and the deciding I'll leave it till tomorrow. I'll deal with it tomorrow, and then you will have my order by tomorrow in regard of the CMC decisions. So actually, we can proceed then to the variation order.
So be it, my lord.
Okay, and the variation is Mr. Page who should start first. Is that right? Who addressed the court?
Yes.
My lord, yes, it's my application, and I thanks very much for giving me some time. I confess I didn't anticipate you would agree to push back the CMC decision, but thank you for giving us a bit more time on this point. I hope you have seen my skeleton argument that has addressed the variation.
I did.
It picks up the story.
It's all about this spending. It's all about the spending that you're allowed to do. Is that right, Mr. Page? Yeah.
Exactly that. Yes. So in broad terms,
I would finish this in 10 minutes, Mr. Page.
Pardon me?
I would finish this point in 10 minutes.
Right.
Go on. Take your time. I don't want to confiscate the time that's allocated to you, Mr. Page.
Okay. Well, Lord, if you have clear preliminary views about the points, and I'd obviously welcome hearing them, and then I can address them in my submissions to the court.
Not at all, really, not at all.
Okay,
deal with it from a fresh mind, yeah.
So I'm looking here in the application bundle, which has been, I think, filed separately with the court. The freezing order that you made in August 2018 contains, adopts, broadly speaking, the standard wording for a freezing order. And importantly, there are two things to note about this freezing order. First
is that a compliment, Mr. Beach?
Everything I say to the court, my lord, is a compliment to the court.
Thank you.
So perhaps if we turn to page 42 of the application bundle.
Will that find under which GHI? Where is that?
So this bundle, I don't think has letters attached to it. At least not on my version.
And I always wonder why parties have another version than the one I have.
So this is a
Okay, this is start J, K, L, and M.
It's a 60-page bundle.
Okay, what's the page appearing in your system now?
I'm afraid for me, I've printed it off and it's in hard copy.
Would
So
you
I
please
don't
help?
have a court PDF reference. I don't know whether Mr. Reed does and can assist.
So what can I help? What is it you need?
The application bundle and where it might be located.
I refer to it, my lord, as the V bundle for variation. So it's, as Mr. Page says, it's 60 pages. It has section A and section B. It's not the CMC and it's not the main bundle.
Yeah, but I know it starts with the tab J, K, L, and M.
That's it. That's it.
Yeah, I'm in J now. I have my order open before me.
Perfect.
So the application notice is at J3.
Okay, J3.
So, my lord, I want to take you through to your freezing order.
What?
And so your freezing order, if we just track it through very quickly, it broadly adopts the standard form freezing junction structure. We have the preamble at paragraphs 1 to 4, and then the meat of the freezing order itself is at paragraph 5. And it's made clear as to the jurisdictional scope of it and the money that is being injuncted under the order. Paragraph 7 identifies some particular assets that are being injuncted.
Yes.
And then paragraph 8 is the usual provision that if we have assets above the specified sum, then we can deal with them as we see fit.
Yes.
Paragraphs 9 and 10 concern the affidavits and the information disclosure, both about information of assets and tracing. And that goes through to paragraph 12 and 13, deals with NBK. Paragraph 14 then deals with the exceptions to the order. Now, in the exceptions in the order, we have paragraph 14.1, we have the personal living expenses exception in the first part of 14.1. We then have the legal expenses exception in the second part of 14.1. Mm-hmm. The second sentence of 14.1 places a condition on that, again as it's standard, that these permitted categories of expenditure exist, but they are subject to providing prior notification by the paying party to the claimant. And then 14.2 is the effectively set aside point. Well, if we pay money to court or otherwise give security for the full sum, then we can do what we like with the balance of our assets.
Right.
So that then is the broad structure of the operative parts of the order for the purpose of this application. What paragraph 14 does not include is what's called the business expenses exception, and one sees in the standard form order appended to the IFC rules that ordinarily one sees the form of wording broaden the lines that expenditure can be incurred if it's in the proper and ordinary course of business by a respondent. Now, just standing back and understanding both what freezing orders are and why that business expenses exception appears in the order, it is an important step in this application. And I recognise that the DIFC makes on a near daily basis at the moment, and that these orders and the structure often is very familiar to your lordship. But nonetheless, it is appropriate in this application just to go back just a little bit to first principles and to remind ourselves what freezing orders are and are not all about. And once one looks at that, the inappropriateness of excluding the business expense exception becomes clear and apparent, and indeed unique. So freezing orders concern, generally speaking, they can be made either at the start of a case or post-judgment. Where they're made at the start of a case, they're obviously interim remedies, and before there's been any substantive consideration of the merits of the underlying case. A claimant has to satisfy the relatively low bar that it has a good arguable case on the merits. And in this case, that was passed, but also it's right and proper to say that this case falls in the main category of claims before the DIFC, which is that both parties have put forward cases which each other accepts is a good enough case to go to trial. And so the court should have no clear view about which party is going to succeed at trial, or that the merits from one side are particularly strong or the other. I could frankly waste much time now in setting out why the case is misconceived, but it just doesn't help the court resolve this point. This case falls in the broad middle category of cases that should go to trial, and it's important that the court adopts the assumption when considering its application that there is a prima facie case for the defendant to meet, and there is a prima facie defence that the claimant has to surmount. So the first part of the test to say for freezing orders is about a good arguable case. And then the second limit of the test concerns whether or not there is a real risk of dissipation of assets.
Yes.
And it's that risk of dissipation that is absolutely key. Because freezing orders are granted if the court is satisfied that the defendant might dispose of assets improperly, and that improper disposal of assets would frustrate any attempt by the claimant, if successful at the end of trial, to enforce judgment. Now, what's important there is the qualifying word improper. Obviously, the question then raised up as to what is proper versus improper. And the answer to that question is proper expenditure is expenditure that's in the proper and ordinary course of business. And paying debts as they fall due, little and large and anything in between, is appropriate and should not be stopped, and is not intended to be stopped by a freezing order. So a freezing order is to stop misconduct by a defendant, but it is not there to stop conduct per se. And it conserves assets, say those which are spent through the ordinary ebb and flow of business. The third limit of the test is what's called the just and convenient test, which doesn't raise any issues so far as is relevant for this application. So freezing orders are therefore not intended as some sort of pre-trial punishment for a defendant. In fact, on the contrary, the price of obtaining a freezing order is high on a claimant. A claimant must offer to the court a cross undertaking as to damages, and it must, in offering that undertaking, it has to demonstrate to the court that it has assets to make good the undertaking being offered. So it's not there as punishment for defendant, and it also must not be used as an oppressive tool to force a defendant to capitulate or settle the case. It is not there as a ransom tool for a claimant to use against an opposing party. It's also not intended to prohibit the normal disposition of assets by a defendant. There is a great deal of case law from common law jurisdictions, and obviously I look at those with an English law bent, about whether particular items of expenditure fall within or outside what is the proper and ordinary course of business. But that doesn't change the principle that freezing orders should not be there to stop expenditure that does fall inside that category and does fall inside it, properly speaking. And the final point to say what freezing orders are not is they're not some sort of roundabout way for a claimant to get to rank higher or otherwise obtain security over assets. That's a different sort of application. It's an application that arises as a proprietary injunction in the first instance. That sort of application wasn't made in this case. And there is no reason why other creditors of the company should be forced to stop or not receive any money at all from a defendant just because a freezing order has been put in place. That will be to stop conduct rather than misconduct. So I hope you've also got my authorities bundle, and perhaps just to end the point about what freezing orders are all about, I'll just flag up to you briefly the relevant extracts of one case, and I'll go on to my second point. So the case I'd like to just draw the court's attention to is the Ablyazov case in the Court of Appeal, English Court of Appeal. This starts at page 38 of my authorities bundle. I don't know if your lordship is able to find that document.
Not yet. Well, I see a tag called authority, which is referred to by letter L for third defendant application to varying authorities.
And then I think that's probably it.
When I open that, which is called L1,
the first page is blank.
is that Iraq Ministry of Defense?
Yes. So, what I've done is I've put together a whole series of, in fact, there are 1, 2, 3, 4, 5 cases there as a single PDF. So if you scroll through that, inside that tab, to there is red numbering on the bottom right hand corner to page 38.
Yes, I mean.
So page 38 should be the front page of a case called JSC BTA Bank and Ablyazov.
Exactly.
So the Ablyazov litigation is a very high value, very long running piece of litigation that went to the Supreme Court on various issues, but not the points I'm going to be discussing in relation to this judgment. That was, as I say, it involves freezing orders, multiple billions of dollars of stolen money, and by the date of this hearing before the English Court of Appeal, there had already been findings of contempt made against Mr. Ablyazov. But nonetheless, despite that very adverse background to the case, what was being sought there by the defendant was to enter into certain transactions. Now, the freezing orders imposed already contained the business exception, the business expenses exception. And it's important to note that despite the very serious misconduct, nonetheless, the exception was still in there, and there was no suggestion that it should be removed entirely. The question was whether or not particular expenditure fell inside the scope of that exception. So there are just a couple of extracts that I wanted to draw to your attention. The first, if you go through to page 45, the red 45.
Yes.
And on that page, in the paragraph paragraph 15, the final sentence of paragraph 15 summarizes in a sentence what the purpose of a freezing order is.
Yeah.
And that is a general statement of principle. See there, it says, the purpose of a freezing order is to prevent a defendant against whom a claimant might in the future secure a judgment from disposing of his assets otherwise than in the ordinary course of business, so as to frustrate any attempt by the creditor to secure payment of its judgment by whatever process of execution might be open to it. So the exception there is front and centre within the purpose of the freezing order. If one then scrolls down through to page 51 within the tab,
yes.
We have here section starting at paragraph 34 that explains just above that, broadly speaking, Lord Justice Beaton is saying that there are three overriding principles that are at play in freezing orders. The first is the enforcement principle, i.e. to stop the injuncted defendant dissipating monies, i.e. spending monies improperly. Then the second principle is a principle of flexibility, and that's explained at paragraph 36. And the idea there is that defendants may misuse the business expenses or personal living expenses exception, and the court need to be alive to that. But the answer of how to be alive to it isn't to remove it entirely, it's to carefully police the business expenses exception. And then the third principle of paragraph 37 is what's called the strict construction rule, which is that freezing orders are intended to be served directly on lay persons and have penal consequences. And so they need to be clearly stated and easily understood, and therefore strictly construed. So those are the basic principles about what a freezing order is. I then go on to my my second submission, of which there are I've got 6 relatively brief points to make to you overall, my lord. So this is the second point, and the second headline is this: that the business expenses exception should only ever be excluded for post-judgment freezing orders, and even then in only certain circumstances. The business expenses exception should never be excluded from pre-trial freezing orders. In the English courts, one has to go back almost 20 years now to find the last example where a freezing order did not contain a blanket right to spend money in the proper and ordinary course of business. The leading authority to make good the proposition is a case called Nomihold, Nomihold Securities and Mobile Telesystems Finance, and this is within the authorities bundle, red numbered page 20. And so, Lord, if you're able to find that briefly.
I do have it here.
So the Nomihold case concerned an arbitration award that was being enforced in the English courts. So that then the question was, where did that fall on the spectrum? Is it a pre-judgment interim order, or is it a post-judgment freezing order that means that the business expense exception shouldn't apply? The court found that it is in a grey area and that discretion has to be exercised. The first instance judge concluded that it should be treated as a post-judgment award with no business expenses exception, and that was overturned by the Court of Appeal, who then exercised their discretion afresh and allowed the business expenses exception, even here against a defendant who had been through a fully contested trial and had lost, and then whilst there were jurisdictional challenges to the award, there were not substantive challenges to the arbitral tribunal's award. So just picking out a couple of points of general principle from the judgment. First of all, in the head note, so this is still on page 20. If one looks at the final section of what the court held, you'll see a passage right at 1, 2, 3, 4, 5 lines there in that final substantive paragraph, saying that as a matter of first principle, the defendant should be permitted to meet obligations falling due in the ordinary course of business, that the claimant had not demonstrated that there was some exceptional circumstance which should lead to the court adopting a different course, and that accordingly the ordinary course of business exception would be restored to the order. Looking inside the judgment itself, if we look at we track through the findings made by the lower courts, and then we get to the discussion by Lord Justice Tomlinson, which starts at page 31 of the authorities bundle.
Yes, go
on. And over the page, he cites some earlier decisions. We have the Candex and Bank of Zambia case, and the quote that he gives from Sir Thomas Bingham, who's then Master of the Rolls, saying a Moreva junction is granted to prevent the dissipation of assets by a prospective judgment debtor or a judgment debtor, so either pre or post judgment, with the object or effect of denying a claimant creditor satisfaction of his claim or judgment debt. Turning on to the next extract from that same case, but from Lord Justice Aldous, the second quote there on that page makes it clear that it's not intended to start getting involved in a securitization of the claim. The quote is, "It is not and never has been an aid to obtaining preference for repayment from an insolvent party." Then over the page at page 33, paragraph 34 of the judgment, I say, to the extent that my application can be summarised in a single paragraph in a single case, it is summarised here. Mm-hmm. That Lord Justice Tomlinson quotes a sentence from G on commercial injunctions, and entirely with approval. The purpose for which injunction has been granted or is being maintained is an essential consideration in the exercise of a discretion as to whether the injunction should be varied or discharged so as to release assets to be dealt with by the enjoined party.
You just referred to discretion.
But yes, excuse me, at the discretion point, there is in fact a later section, a different case, where we go back to G and we talk about the business expenses exception. Paragraph 37 of the judgment, Tomlinson brings different threads together and talks about the point of principle underlying all of this. So he's saying here that even though we're talking about post-judgment orders, as a matter of principle, post-judgment freezing orders should still contain the ordinary course of business exception. And there would need to be special circumstances to get a different result.
So in this paragraph, he's not making any distinction between a normal enforcement cases or case based on a very high threshold of evidence like fraud.
So in paragraph 37,
yeah.
So in paragraph 37,
he's very general
here about freezing orders granted after the making of an arbitral award.
Yeah.
So a case which is far further on from this case. He's talking here necessarily about a claimant that has satisfied the good arguable case test and has satisfied the real dissipation of asset test, and so is over the threshold to get a freezing order in the first place. The question is whether or not that freezing order should permit any trading activities by the defendant whatsoever. So you're dealing with someone here who the court strongly suspects is a fraudster and will play fast and loose with paying up on an award that's been made against it. And the court says that even in those circumstances, the business expense exception should still be there. Now, as I understand it, this is my third submission, that the claimant does not dispute what the underlying principles of law are, and there's been absolutely no pushback and no reference to authority from the claimant to suggest that the business expenses exception is in some ways an optional add-on for the court that it can include or exclude as a matter of choice in any individual case. The fact that the business expense exception appears in square brackets in the standard form order and the rules of the IFC simply reflects the fact that in a post-judgment freezing order, that exception is open to some limited debate. It does not suggest, far less provide any principal basis to suggest that that clause can be removed entirely for pre-judgment freezing orders, which is the situation here. And the business expenses exception it has a very long pedigree in the English commercial court. That goes back to the Iraqi ministry case, which is from 1979, and that it's at the start of my authorities bundle. I'll just flag up to you the section I rely upon there. That's at page 8 on the red numbering.
Yes.
And with the following, tracking down the letters on the right-hand side of that page, it's the by letter D with a paragraph starting "for my part."
Yes.
Through to the start of the next paragraph, the first couple of sentences of the next paragraph.
Yes.
And again, this goes back to the point I was making earlier about what freezing orders are and are not about, and how the importance of the business expense exception sits inside that. The case, the 20-year-old case that is the last time this was ever seriously debated in the English court as a point of principle is the Halifax and Chandler case from 2001. Now that starts at page 10, and if you track through to paragraph 5 of that judgment, you'll see the first sentence of paragraph 5 records that the underlying freezing order did not contain a business expenses exception.
Yes.
Then if you track through to paragraph 16 of the judgment, you again have the statements of general principle. It is well settled that a freezing injunction is not granted in order to provide the claimant with security for its claim. It is, at least in part for that reason, that the standard form permits a defendant to spend money on legal expenses and indeed on ordinary and proper business expenses. The order ordinarily either includes a specific weekly sum for legal or business expenses or permits a reasonable sum for such expenses. Now, there's a passage in G which is quoted, and in fact, the one I want to particularly stress to you is this passage now, not the one I was talking about earlier. And that is at, if we pick up the story at paragraph 18 and go through to paragraph 20, the last sentence of paragraph 18 I rely upon, where the court says, as I see it, that is because the purpose of a freezing injunction is not to interfere with the defendant's ordinary course of ordinary business or his ordinary way of life. In the fourth edition of Mariva Injunctions and Anton Pillar Relief, G says, and then towards the end of that quoted section, after the last comma, 1, 2, 3 lines up from the bottom, the passage I particularly rely on is this: there can be no objection in principle to the defendant's dealing in the ordinary way with his business and with his other creditors, even if the effect of such dealings is to render the injunction of no practical value. Paragraph 20, in my judgment, the relevant principles are correctly stated in that passage. So we have there the leading textbook being approved by the English Court of Appeal, saying that not only should a business exception be there, but that it would be improper for claimants to object to it be there. There can be no objection. Now that is what ought to be applied in this case. Now, ought to have been included in the freezing on this case, but it wasn't. So I say that my application should be granted on the basis of those first principles just set out, which I've just gone through. To the extent that the court looks to exercise its discretion and think in other ways or angles about the application, this is going on to my 1, 2, 3, 4 submission. My fourth submission is that is my first discretionary ground that I rely upon. That's that the claimant was under an obligation to flag the exclusion of this clause in its application, and should now be punished accordingly for not having done so. I make good that proposition by relying on the case of Tugashev and Orlov, which, if my lord scrolls through to page 72 of the authorities bundle.
72. Yes.
So this was a case where there was an allegation that the claimant had failed to give full and frank disclosure to the court. Now, it's vitally important for the court to uphold the integrity of ex parte hearings. When one party has the indulgence of the court to come before it on no notice and in secrecy, away from the other side, it is incumbent on that party to provide to the court a full and frank and fair exposition of the underlying facts and the underlying law, including those points which are adverse to it. In the event that it fails to do so, the court not only should exercise its discretion afresh. But in fact, the starting point, as is held in the Orloff case, and here is paragraph 7 onwards in the Orloff case, with a whole series of legal propositions which are summarised. The starting point is that the whole freezing order should be set aside, regardless of the materiality of the non-disclosure, to the extent that it may have been material to consideration, but still the court would have made the same order regardless. The court needs to know that when litigants come before it, particularly represented litigants, those litigants can be trusted to be fully open. Now, we don't quite know what happened in this case, and SBM and Dentons have not covered themselves in glory by failing to explain clearly and carefully how it was that the first principles I've just been through to the court came not to be brought to the court's attention when the original freezing order was sought. We are prepared on our side to assume that it was a matter of innocent oversight by them, and that they are now effectively seeking opportunistically to rely on that innocent oversight. We're not going so far as to say that it was conscious misconduct by the legal representative of SBM. Nonetheless, the court, having found itself making a uniquely onerous order on Prime, and having discovered that it made that order without being alerted to that fact by SBM, should now start the proposition that it's prepared to set aside the freezing order as a whole. I don't go as far as that, though, and I seek only that the variation is permitted so that Prime can carry on trading in its ordinary proper course of business.
You saying the order to set aside the order entirety or against your client, Prime?
Obviously, I'm only speaking about the situation between SBM and Prime. I don't speak on behalf of any other defendant, and I have, frankly, no interest in what happens to other defendants. So that's my first discretionary ground. My second discretionary ground, and this is submission 5.
Alternatively?
It's not alternative, it's further. That ordinarily, arguments about proper and ordinary course of business concern the spending of money, and the whether or not dissipation is legitimate or illegitimate that's being proposed to take place. Now, any such argument should be within the confines of we're permitted to spend money if it's in a proper and ordinary course of business, whereas here there's a total prohibition. So that issue in some ways doesn't arise at the moment. But it's a remarkable feature of this case that actually Prime has very limited meaningful assets. So what we're not looking to do is spend down our money, because in short we have none. What we're looking to do instead is to recommence trading, which will ultimately be to our benefit. And indeed, if SBM were to succeed in the case, it will be to SBM's benefit, because we will therefore be able to make a profit over the coming 6 to 9 months, and there'll be more assets for SBM to seek to enforce against. Our statement as to what our assets are set out in Ali Sadr's affidavit, disclosure affidavit, given back in June. There is some grumbling about that by SBM. There's been no committal application in respect of it, and certainly we refuse entirely any suggestion that anything said in there is untrue or misleading. After the issues with Renish came to light or transpired in May, June, July 2018, there was a period of time where Prime's trading activities effectively ground to a halt. Those were then restarted, albeit from a lower base and with less access to capital, and that carried on for a period of around 1 year. but it then had to come to a complete stop, and it did come to a complete stop in October 2019 when the freezing order was discovered, and I discovered that exceptionally there was no business expenses exception. So the second discretionary ground is that we are not looking to dissipate money, we're looking to earn money here, and that there is no principal ground to be refused to be permitted to do so. The third discretionary ground I rely upon is that the court can grant me the order subject to conditions. And I said earlier, the court can see me as Mr. Compromise in this hearing, but we are clear that the business expenses exception, just as with the legal expenses and personal living expense exception, comes at the price that there must be prior notification by us as to where the money has come from. Now, that notification regime in the freezing order, as is currently in place, permits, in theory, a notification immediately before payment. Now, we stand ready to engage in a sensible discussion with either the court or SBM as to whether or not the period of time should be increased, there should be further detail provided, and we can then have that sensible discussion. What is inappropriate is to have an in-principle prohibition on all trading by my client. So the terms of the draft order, we say, are effectively they are adequate, but they are nonetheless accepted to be a potential starting point for the court. We are content to engage with a notification regime, and we'd be content to look at that further. It may even be that the court's decision is that it taken on the broad principles, subject to clarification of notification, and perhaps coming back to the court on papers if we can't resolve that point between the parties. But I flag the point because I say that, again, this is not an all or nothing situation, and this ought to be the situation, an application that was contended to in principle by SBM, with then the details to be resolved. But because of taking a principled approach, that detail and nuance in the drafting of the order hasn't yet been debated between the parties. So those are my principal submissions on the application. The claimant's opposition stems from effectively post-freezing order conduct. I say that none of that is relevant.
Excuse me, Mr. Page, before you go to that side, would you please take me to the amount of expenditure and the source of expenditure and the limits of expenditure that's in your mind?
In the freezing order?
Yes.
Yes, certainly. So in the freezing order, I'm here in the application bundle. So it's with Mr. Reed's terminology, it's bundle V for variation. Paragraph 14.1 in page 46. So this is paragraph 14.1 of the freezing order. The expenditure on personal living expenses for Prime is 0, as you'd expect it to be, because it's a corporate, not a personal individual. The expenditure on reasonable legal expenses is uncapped. The expenditure on business expenses permitted is 0.
Are you referring to the order now? Or,
Sorry, I thought the question, my lord, was what level of expenditure is permitted under the order.
No, I said in what you're looking for. Your request. I'm referring to your request, to what limit you want to go.
Certainly. So
I mean, I understand your primary submission is that the order must be left because of lack of frank and full disclosure. But otherwise, if the court is to have to catch the stick from the middle and to apply discretion, to what extent your client shall be allowed to expend?
So, my lord, the answer is if we go to the application bundle, the draft order, which is at page 3 of that bundle. As you'd expect, this sets out our primary position, which is simply that we have an in principle right to spend money in the proper and ordinary course of business. My fallback position is not that there is any cap on that expenditure, because I don't think that can and should be sensibly imposed by the court. But my fallback position is that we can draft a further sentence or paragraph saying that before such expenditure is made, the Prime provides to SBM not less than 24 hours notice with information about where the money is to come from, the nature of the expenditure, and to who the money is going to be paid to. I.e., to provide SBM with enough information to interrogate to some extent the payment. I don't pretend that any level of information we could provide SBM would satisfy or is likely to satisfy SBM, but nonetheless, it would be a good faith process of providing a meaningful level of notification for SBM to reach a decision as to whether or not to make an application to the court, which we would then have to do in the way that one commonly sees in the English courts, as to whether or not a particular item of expenditure falls within the proper and ordinary course of business. But what, of course, the introduction of the exception would permit is not simply that we can spend money, but also that we can enter into contracts and therefore earn money. And I'm saying principally that that's what we want to be doing in this case. Now, I can't provide granular details of that because that's the nature of commercial dealings.
For now, nothing stops you from entering into a contract with anyone, but you need to rely on something that you need to spend to earn money. That is your point. In order to spend, we understand what is your. We understand. Mr. Reed said you have no course of business at all, but you want to refer to an ordinary course of business, and that must have a, let's say, some evidence. What is your ordinary course of business expenditure limit is? Whether maybe the court need to know how much you expend. What is your normal expenditure when you do your business? You have not done business, I guess, for the last 2 years, maybe, but.
Well, my lord, yes, because we haven't been operating. Prior to 2018, operating in a very different environment.
Shall we treat you as a startup company that it will need, I don't know how many $1,000 per month, maybe?
So, my lord, the narrow answer to that question is that evidence isn't before the court for this application.
Okay, no evidence, yes.
So we say it isn't necessary because this is a point of principle rather than a point of nuance. But at the moment, we have a total prohibition on dealing with any of our assets. So it isn't simply we can't spend our assets, we can't deal with our assets. And the only sensible way to apply that prohibition is by not trading at all. There are some obvious minimal things we can't do. Like we can't pay our rent on the office premises. In the Hamia free zone. We can't pay accountants to prepare filed accounts. The defence of the claim can only be possible through through some permitted expenditure there or third-party payments, payments from the ultimate beneficial owner, which therefore fall outside the scope of the freezing order. So, in effect, the
That's what I'm saying. Mr. Page, your case is not giving the court the discretion and in what way it should deal with your application. You just telling me, would you please lift that band? So let me do whatever I want with my money, with my assets. I think this ends your case, but I would let my opponents know what I'm doing and where my money goes.
No, Malol, I should be very clear.
That's the extreme of your case.
So it isn't my case at all. Any improper expenditure or improper dealing with assets by Prime would be in breach of the freezing order and would lend itself and its officers liable to proceedings for contempt of court. So the introduction of a business expenses exception in no way impacts upon the force and gravity of the freezing order, just as the court makes freezing orders day in, day out against other parties. So that order remains, and there is a very serious and personal consequence on the directors should they cause a company to be in breach of it. But what the introduction of the exception does do is it permits legitimate expenditure. And I go back to the phrase I used earlier, we can have conduct but not misconduct.
Understand legitimate expenditure.
And any proposed expenditure is subject to a notification regime.
No, I'll go again with you. Well, sorry for taking you step by step. When you said permit a legitimate expenditure, would that expenditure have a cap, for example? A certain cap, a reasonable cap, or what we just say, reasonable, for example, reasonable legitimate expenditure, or
yes, so well,
or $10,000 legitimate expenditure, or how it works?
So the wording we're proposing in the order is reasonable and proper and ordinary course of business. It isn't something that's been explored before today. I don't have any instructions to assist with any specific level of cap on expenditure. I simply have no idea. I have to take instruction on that point. But it follows from the case law that underpins the phrase proper and ordinary course of business that that is extremely limited. What a party can do is it can obviously pay debts on sums falling due under underlying bona fide contracts that have been entered into prior to the freezing order. There is then a question of fact and degree about the extent to which it enters into new contracts and new business. So if Prime wanted to become a theme park operator, that type of expenditure would probably be prohibited under the freezing order because it's got nothing to do with its history as an importer and exporter of bitumen. So these questions can't ever really be resolved in the abstract. You need to have particular transactions which are being analysed by the court. But this application isn't about that. This application is about the point of principle.
I understand what the principle taking you to the extent to the exhaust of all assets of the company. And that, in your opinion, that would still within the meaning of ordinary course of business.
Yes, and I should be clear that my opinion is entirely irrelevant. My submission is that's what it is.
Okay, I understand this point. You might deal with Mr. Reed objections, if you wish.
So I think I'll, in terms of Mr. Reed's objections, principally, I think it'd be sensible for you to come back to them in reply. But I can make a couple of broad points now.
No, if that's you can do it twice. I mean, you either take them now or later, Mr. Beach, I guess.
Okay. Well,
Maybe later.
I think the only point that I'll say now, and I'll come back to these other points later,
Yes.
is that Mr. Reid says that we are too late in making this application now because the freezing order was made and the return date has happened,
It missed.
and that we have to show a material change in circumstance. Now, the authority, I'm not sure he expressly relies on authority for the point, but the authority that stems from is a case called Tibbles and SIG. And what I've made you this while Mr. Reid is giving his submissions to you is make sure we can all look at that case, because that case is very clear that whilst ordinarily you do look at change of circumstances, the court will still look at whether or not something went wrong in the original order, and its discretion isn't fettered in any way. So in a situation such as here, where something did go wrong in the original order, it is still appropriate now for the court to look at it. So that's point one response to that. Point two is that it's a fairly speculative position to say, well, look what all happened in August 2018 and we didn't engage then. This point has already been answered and dealt with extensively in both in evidence and correspondence. But we did not know about the applications, certainly obviously the ex parte application, nor did we receive notice of anything prior to the return date hearing. So we were not able to come to the court sooner. And this is now the application. This is the first time we are approaching this. There is no sense of having two bites of a cherry or anything that's improper about being done now. We have we are continuing to be bound by the order, but it is right and proper that the order is varied so that it is kept within sensible means, and is not this wholly unique and extraordinary and wholly improper order that has been in place between August 2018 and up to now.
So in brief, you're saying the claimant conduct by not addressing the court about the expenditure point shall allow, which their negligence shall allow this court to revisit this point without the need for any new circumstances and re-examine your rights of this legitimate expenditure of ordinary business level. Is that what you say?
Yes, that is one of my grounds, in effect.
Okay. There is another ground?
And then my other point in relation to change of circumstance is that we were not present in August 2018. So you can't hold it against us that we didn't raise the argument in a hearing that we didn't know about and we didn't turn up to.
Okay.
So, Lord, that's what I've got to say at this junction. I think probably helpful to give us a reason, and I'll come back perhaps on other points in reply.
Yeah, for sure. Thanks, Mr. Vij. I'll come back to you.
My Lord, I wonder
Mr.
if I could start with a rather sceptical observation. We are told that Prime, in business terms, is essentially Mr. Sadra and his laptop. It seems extraordinary that a company would wish to that if Mr. Sadra wanted to restart business in oil trading, he would wish to do that through a company, Prime, that potentially is liable to $30 million in these proceedings. It would be far simpler, as your lordship suggested, to effectively have a startup or use a startup company.
Well, you would to pay that debt first.
Well, Mr. Sadra is quite capable of acting indeed as a startup without the 30 million prospective liability of Prime. I'm also mindful of the fact that that Prime purports to be suing for $53 million in, we're now told, Dubai court proceedings and possibly other jurisdictions. So my cynical suggestion is that all of this may be about seeking to protect any recovery in those Dubai court proceedings in such a way that they can then be used ostensibly as part of ordinary business, but in fact, as we've seen, and as I will show the court, that business has been used, we say, to dissipate monies that could be used to satisfy the likely judgment against D3 in these proceedings. That's just a note of cynicism, my lord, to start matters. I do make the point that the decision to vary a WFO and whether or not to include or the ordinary business exception is a matter of discretion for the court. Of course, it's bound by broad principles. My learned friend has taken you to some very broad principles as set out in the leading authorities of which we're aware, and I suspect your lordship's aware. That's to say, a freezer is not to be used to secure assets against unsecured creditors. A freezing injunction is not to grant a preference to one creditor over others. Of course, all of that is right. Of course, the court would have known it. If I had attempted in the freezing injunction application, Mr. Wheel on the continuation application had attempted to lay out those authorities by reference to those decisions of the English court, I suspect that the response of your lordship would have been to refer me to the leading DRC decision, Ithmar Capital and Nate Investment, a Court of Appeal decision in which the principles dealing with freezing injunctions were amply set out by Chief Justice Evans. There would be no need, and there was no need, for me or Mr. Wheel, or indeed the court, to set out basic propositions in respect of the general principles which are well known. Now, beyond those principles, we say there are no rules as such. There is no authority which my learned friend could point to which says that only in the case of a post-judgment freezing injunction can the exception be made. If there was such an exception, he would no doubt, it was such a case expressing such a rule, he would no doubt have taken it to us. He did. Mr.
Reed, I'm afraid you're flatly wrong there, and I did take his lordship to.
Can you come back by way of reply?
Well, I'm afraid it's not fair for you to misrepresent what I've said to the court.
You keep the Mr. Page for the return, yes.
What he then seeks to do is to build references to practice. So he refers to certain cases as being the first case or the last case or the only case or the unique case. Curiously, none of that was built up in his skeleton. So those instructing me haven't been able to check whether in fact the relevant case is in fact the last case or the first case or the only case. And that attempt to suggest practice has been made by way of oral submissions in this hearing. So in those circumstances, we remind the court that it is a matter of discretion. Now, an allegation has been made that we improperly failed to explain to the court
address the court.
Yes, how the DFC court, how freezing injunctions work. I think there is a need for a reality check here. We are dealing with, putting ourselves back, and your lordship, back into August 2018. There were very significant suggestions of inferences of fraud. So the first and second defendants had ceased responding. They appeared to have absconded. They had obtained by deception $30 million, which they had failed to pay. Their offices had been abandoned. Prime's offices appeared to have been abandoned. We are now told that they have never effectively been used. There was no evidence of any business in Prime's offices. And the inference was that Prime was involved and would therefore be a constructive trustee. Now, my lord, if those are not special circumstances, then I struggle to understand the approach being taken by my learned friend. It is not the case that fraud is required for any freezing injunction. A freezing injunction can be established where there is a good arguable case on the merits and there is a risk of dissipation of the assets which may be used to satisfy judgment. It has been made abundantly clear in decision after decision that there is not a requirement of fraud or dishonesty. There are many other situations in which it is likely that it will be difficult to enforce, difficult to satisfy judgment, and that a freezing order can be made. The additional elements, the special circumstances in this case, are the very strong indicia of fraud. And in those circumstances, we say the court was entirely justified in excluding the optional exception. And I do say that the square brackets make that optional. And I do say that the square brackets are not specifically related to specific circumstances, such as a post-judgment freezer, or such as an application for a proprietary injunction. Your lordship was faced with a strong case that Prime was a conspirator in a significant and complex fraud, that Prime had no business because its business premises appeared to be entirely unused, and that Prime was holding SBM's money owned by SBM. In those circumstances, the freezing order was to be served on an email address, which we've seen, the RP shipping email address, which is owned and controlled and admitted as such in the RRFI to be owned and controlled by Prime, and was served further on the PO box of the registered office in Hamria. So reasonable steps understood and explored with the court were taken to serve the freezing order on Prime at its registered office and at an email address which it owned and controlled. We were met in those circumstances by silence, and we say by contempt, on the part of Prime. Then, in terms of the development, we received the disclosure from NBK, pursuant to your Lordship's disclosure order made on the 7th of August at the time of the continuation. And what we saw there was the details of the payments out of the NBK account, the Prime's account with NBK, and I don't think I need to take your Lordship back to it. It's set out in the particulars of claim in paragraphs, I think, 56 to 58, which are agreed in the list of issues as being agreed, and essentially very substantial sums are paid both to Renish and to its associated company Petrochem, and indeed to Prime, internal transfers made to other Prime accounts. In total, 11.6 million was transferred to other Prime accounts, 11.3 million was transferred to Renish and Petrochem. Now, if that is said to be the ordinary course of business, then it seems pretty clear that ordinary course of business, as alleged by Prime, can involve some very significant payments, which even now, nearly 2 years later, are almost impossible for Prime to explain in terms of what those monies were doing, why they were taken out. How could the judge on application or on being notified, or how could SBM on being notified possibly begin to investigate in the 24-hour period posited that as to whether those sums were properly within the course of business? If the business, so-called, it constitutes these very large sums of money paid back to Prime, paid to Renish, or paid to recipients who have still not been identified. And we say these payments, these monies paid out of the Prime account back to Renish or to other Prime accounts within a very short period of time, often in round numbers, are further and strong evidence of fraud on the part of Prime. We do not shrink from that, my lord. We accept that it is a serious obligation, but we make it, and we make it with some force, on strong evidence. The explanation that we were provided with in the defence as to these being third-party payments to avoid KYC regulatory obligations on the part of Prime's banks, or that they were to provide access to oil products that come from Iran. The explanation, so-called, that this was done on an open ledger basis without any documentation, all of that, in my submission, strongly supports the strong evidence that there is an inference, a strong inference of fraud. It is not, as it, I think, suggested my learned friend Skeleton, a strong defence to fraud. It is barely an arguable defence to fraud, albeit that we accept that it has to go to trial in order to be properly tested and dismissed. The defence, I should say, has several further allegations. Firstly, that the Hamria office, for which it's now said rent is required, is not occupied and is merely required to allow Prime to be established in Sharjah. Secondly, it said that there is no forwarding of mail from the registered office of Prime. Again, in our experience, in our submission, that is a further suspicious circumstance. Thirdly, it said MBK simply told Prime that the account was closed for regulatory reasons. Now, if you're Prime, if you're a legitimate business and you're told by MBK, one of your banks, that all of your accounts with MBK have been closed for regulatory purposes around in late 2018, one would anticipate that you would investigate what those regulatory reasons were, and that investigation may itself disclose the fact that an order has been made, a freezing order has been made. But no such investigations are suggested on the part of Prime. And finally, in the defence, it suggested that Prime ceased, I shouldn't say it suggested, it is pleaded in terms that Prime had ceased operations. That pleaded position, as late as the 31st of March 2020, so 6 months ago, a pleaded allegation that Prime had stopped all of its business And that was certified by a statement of truth. There were no ifs, there were no buts, there were no, well, maybe in the future we'll resume business. It was said that Prime had ceased operations. That is the position as set out, as pleaded in their defence. And it's very odd for Prime now to come back and say, well, actually, that's no longer the case. We wish the court in its discretion to allow reasonable conduct of business, notwithstanding that we pleaded 6 months ago that we had in fact determined all of our business operations. Moving on in our narrative, in August 2019, Prime found out about the proceedings, or that's what it says. And I think we've been told in additional detail by way of submissions from Mr. Page this morning that it found out because of the hearings, mutterings within the DIFC. Now, if you find out that there are proceedings against you in the DIFC court, ordinarily one would expect the party to look at the court file, and Prime would have readily discovered that, in fact, there was a freezing injunction. But no, we're told that it wasn't until October, some months later, that they became aware of the worldwide freezing order. And it is said that since then, they have complied with the freezing order. As for the provision of information order, we are told that it was already too late to provide information and disclosure. My lord, that is an absurd defence. The idea that you are told to disclose documents within 2 days, and you then say, whoops, the 2 days have passed, I'm no longer bound to provide those documents. That, if that were the case, that would obviously give an advantage to parties that simply failed to give disclosure within the required time period, and could then say, well, look, the obligation is now discharged, I can no longer comply, and therefore there's no need for me to provide documents. That, my lord, is risible, is laughable as a defence in seeking to explain why disclosure was not given pursuant to the provision of information order that was attached under a penal notice to the freezing order. And indeed, that position was made absolutely clear by SBM solicitors Denton's in a letter of October 2019, that the obligation to give disclosure was outstanding and that Prime was in contempt. It was only on the 30th of June this year, 3 months ago, or 2 months ago even, that purported compliance was given. That was 2 years after the original freezing injunction, after the original provision of information order. The asset disclosure that we have received, my lord, is entirely deficient. The freezing order is quite clear in what is required. What is required is information and an affidavit. Now, we all know that an affidavit has the special quality of being sworn evidence. That has very serious consequences if the evidence is found to be false, not least that the deponent has committed the criminal offence of perjury. Now, the affidavits of both Mr. Farhang and Mr. Saad are unsworn, having been given back in July 2020. Now, we have all worked through lockdown in the DIFC. Many of us have worked on freezing injunction applications which are required to be made on affidavits. Of course, there are difficulties in swearing affidavits. A practice appears to have developed whereby partners in the same firm can witness affidavits as long as they're not working on the case. That is a sensible accommodation. That does not detract from the fact that the evidence given is sworn and witnessed, and that is what has not happened in this case. This court is asked to rely on evidence that is unsworn and there's no witness clearly to the relevant swearing. That, again, we suggest is a further indication that there are concerns as to the truth or the accuracy of the evidence that is included in those affidavits. And indeed, that concern is justified because the explanation provided for the delay is, in our submission, wholly inadequate. There's no explanation of why it took so long to discover the freezing order. There is certainly no explanation as to why it then took 8 months, having found out about the freezing order, in order to comply with it, save for the laughable suggestion that once the 2 days had passed, the provision of information order effectively ceased to have effect. There is no substantive evidence provided from Mr. Farhang. He is the sole shareholder and director. The claim on his part to have no relevant information or substantive information is, in our submission, frankly implausible. The burden is therefore on Mr. Sadr to explain the relevant, the alleged legitimacy and the pattern of trading. But the evidence of the bank accounts is entirely incomplete, as we've seen. There are the occasional 1 or 3 months of accounts or statements that have been provided, but entirely incomplete. So it's very hard to reconstruct the trading that is said to have related to the cargoes that are said to be the legitimate trading. The accounts appear to have been operated throughout 2019, and again, being suspicious, there's a strong suspicion that explains the delayed alleged knowledge of the order, because if one looks, for example, if one looks at Denton's letter, which is in the V file, as I called it, at page J55,
J55.
J55. Sorry.
That Abdul Hadi Farhan evidence?
Sorry, sorry, I'll come back to that.
No worry.
If Mr. Wheel could help me find the reference for Denton's letter of the 27th of August 2020. Sorry, it's J71, my lord. My apologies.
Didn't an email to Evershed?
Yes, so it's Denton's to Evershed's, page J74. Mr. Sadr also, at para 318, Mr. Sadr also says that various new bank accounts were opened and significant sums were transferred out following the worldwide freezing order as recently as the end of September 2019, and then a reservation of rights. Of particular notes are bank statements, so CBI statements at little a, various round number deposits of 15 million, 10 million, 7 million dirham in April to June 2018. And then the second sentence of that paragraph, Mr. Sadr's evidence is that the remaining funds were transferred to Mr. Farhang's personal account over a year later on the 5th of September 2019 without any explanation as to why this was made. Similarly, one sees down the page D, Ajman Bank indicates that over 2.2 million dirham were transferred out between the 10th of June 2019 and the 1st of September 2019, a period in which Prime claimed it was not trading. So there are repeated examples, and indeed, and none of that, there's no pushback in respect of that in the responding letter from Eversheds. So they say, and that's at page J77, paragraph 5, they Evershed say, in the interest of time and cost, we do not intend to address the content of your letter and or the second witness statement of Mr. Jeepesh Jari in any detail. Safe to say we do not accept the points as raised and reserve our client's position accordingly. 6, in this respect, our client's position remains that it is fully complied with the terms of the freezing order as evidenced by the affidavits of Mr. Farhang and Mr. Sadr. And I should say, if one goes to the evidence, the first reported affidavit of Mr. Sadr, one sees reference to various bank accounts that were opened in 2019. I will come back to those. So there is significant evidence of flagrant breaches of the freezing order itself. Page V, yes, paragraph 7. Yes, paragraph 7 of Mr. Sadra's affidavit. Prime has the following bank accounts, and then you'll see the Ajman bank account, for example, was opened in May 2019. Going down to D, there's an account opened with Bank Misr. In E, another dollar account in Bank Misr opened around 21st of February 2019.
What are you reading, Mr. Reed?
I'm in Mr. Sadra's affidavit.
J60?
I'm looking at page J58, my lord.
58. Yes, D. Okay, SEI.
And there's a list of accounts that Prime is claiming has, and I'm stating that a number of them were not opened until 2019. So here we have Prime in the year after the freezing order has been made, opening a number of bank accounts. So there's a strong suggestion that Prime is opening accounts, is moving funds around accounts, notwithstanding the fact of the freezing order, which had been, as I say, served, as I've explained, and indeed had caused the freezing of its accounts with BK. And now this court is dealing with the proposed renewal of trading on the part of Prime in this bright new global economy that we have. Since pleading in the defence, as I've said, that it had determined all of its business, that being the position in March of this year, there is no proper evidence as to its current or its proposed trading activity. So exactly as your lordship said, there's no suggestion this is the sort of transaction we wish to do. We wish to trade bitumen out of Iran, and we anticipate that the size of the cargoes will be X. There's nothing against which to measure the alleged ordinariness of the relevant transactions. We've seen the historic trading, which has involved very significant payments out of the account, often to recipients who are unidentified and unidentifiable, with almost no pattern in terms of where monies are going. If one has an ordinary business has suppliers, an ordinary business pays its suppliers in amounts that are generally fairly predictable or regular, and one has some metric by which to assess whether a proposed payment is ordinary. There is no such metric here. Indeed, even Prime itself says it needs an accountant in order to understand its own trading activities, its own accounts. And we say in those circumstances, it would be relatively easy to dissipate monies, not least where it's suggesting that we should have 24 hours in which to investigate the nature of any transaction. And further, in those circumstances where it's impossible to assess whether a payment is in the ordinary business, we suggest there would be a need for significant trust on the part of the claimant and indeed on the part of the court. And the court cannot, in our submission, have that trust as matters stand. We are dealing with murky trading, possibly involving the avoidance of regulatory requirements and indeed sanctions. We have almost no documentation in respect of that alleged business. We have an extraordinary suspicious reliance on Renish, whom all parties accept to be a serious fraudster. We have a lengthy period of non-compliance with a freezing order, with a penal notice. We have continuing contempt of a provision of information order attached to a freezing order, and we have no explanation or evidence of the proposed new trading. So, my lord, in terms of your discretion, we say there is no reason for the court to vary the order that it has already made. As a matter of procedural law, there is a general principle that one shouldn't be relitigating matters, even interim matters such as injunctions. And revisiting includes not only matters that have already been discussed, but matters that could have been discussed on the earlier occasion. That, as your lordship will know, is broadly the principle in Henderson and Henderson. And the rule in respect of interim decisions applies equally. The Henderson rule applies equally in respect of interim decisions. The respondent cannot seek to revisit an existing interim order to which it could have objected, unless there is a material change of circumstance. And we say that places a very strong burden on Prime to explain the material change of circumstance and indeed to evidence the change of circumstance. And so we repeat our submission that where it hasn't done that, where it hasn't explained the trade, where it hasn't given any evidence in respect to the proposed trading, that it has failed to discharge the burden that it needs to discharge in order to relitigate an interim matter. I think it was said that there was no reference to authority, but if your lordship has Vanin Capital, which is a decision which was made at first instance by your lordship. Your lordship may remember Mr. Kharafi earned very substantial mis-selling damages against a bank, and the court made an order for the damages should be paid into court to await a decision as to the entitlements of Mr. Al-Kharafi's funders and lawyers to take their share, if you like, of that recovery. And an application was made by Mr. Al-Kharafi to vary the order that I think had been made in the first instance by Justice Omar Al-Mahari. The application to vary was dismissed by you, and the appeal by Mr. Al-Kharafi to the Court of Appeal was similarly denied. The extra authority was sent to you overnight. The decision that we have in the bundle is not the decision on which I would wish to rely. So hopefully in the bundle, your lordship will have in the page F80. Does your lordship have that?
F80?
F80. It was sent as a PDF to the registry overnight, and it was included by my instructing solicitors on case lines in the master bundle with reference F80 and all.
Make it.
Does your lordship have that?
I think they sent it to me through email.
It probably flips it onto you, in which case you may just be able to open the PDF if
yeah. This is a statement of cost.
It's a decision of the Court of Appeal in Vanin Capital and Al-Kharafi.
Yeah, is that Sir Richard Field?
Richard, yes. Your lordship has it.
Yes.
And if I could take you quickly to a few paragraphs. Paragraph 22.
Yes.
And I don't know if this will trigger any memories, but reading the heading, the first Kharafi application issued on the 9th of June 2015 and heard by His Excellency Justice Ali Al-Madhani on the 29th of July 2015, now some 5 years ago. Paragraph 22 reads, the first Kharafi application heard by His Excellency Justice Ali Al-Madhani, hereafter the judge, on 29th July 2015 was an order varying the order made on the 10th of December 2014 so that $9.4 million odd out of the total sum of $11.4 million paid into court under the earlier order be now paid out to the Kharafis and their trial lawyers, HAS, $2 million be held in court, representing the first tranche payment due to KBH, the law firm, under the consent order dated 9th February 2015, and 3, only insofar as any further damages be awarded against and paid by Bank Saracen, should any further sums be held in court as security for the claims of Vanin and KBH. So that's the application that came before you in July 2015, and the discussion follows at paragraph 47.
Yes.
Relying on RDC 2.10.3, the judge adopted, so that you adopted in paragraph 43 of his judgment, the approach of CPR in the English courts to applications to vary interim orders. Thus, he observed that the rule in Henderson applies so that a party cannot make repeated successive applications where the grounds relied upon in their later applications existed and were available at the time of the application, still less where those grounds were relied upon but rejected by the court. 48. The judge also adopted in paragraph 44 the view of the English High Court in Lloyds and Aga Hansen that the court's general jurisdiction under 3.17 should not be used to vary its orders for the purpose of enabling a party to re-argue any application, relying on submissions and evidence available to them at the time of the early hearing. And 2, in paragraph 45, quoted with approval the following well-known passage from the judgment of Lord Justice Buckley in Chanel and Woolworth. Even in interlocutory matters, a party cannot fight over again a battle which has already been fought unless there is some significant change of circumstance, or the party has become aware of facts which he could not reasonably have known or found out in time for the first encounter. In paragraphs 46 and 47, the judge said, one cannot imagine that parties may be allowed to continue fighting over the same issues surrounding an order without end. The judicial orders must provide stability and some sort of finality to the issues between the parties, even if the issue is not on the merits of the case. And then very quickly, just turning on to paragraph 74, Lord, which is Sir Richard Field's comments in respect of the judgment. So paragraph 74, Sir Richard Field, for the court, as a justice of the Court of Appeal, said as follows: in my judgment, none of these grounds has a real prospect of a success on appeal. The judge's adoption of the hostile approach found in the CPR and decisions of the English High Court and Court of Appeal, such as Chanel and Woolworth, Lloyds and Aga Hansen, Tibbles and SIG PLC, to interlocutory applications seeking to vary or discharge interim orders on the basis of matters or evidence that were raised or adverted to, or could have been raised or adverted to at earlier hearings, is unassailable. Further, this approach clearly applies where the applicant seeking a variation or discharge of the early order was a party to the proceedings in which the early order was made, and however the later application is made, whether by a freestanding application within the original proceeding or under liberty to apply, or, as in the instant case, under a freestanding application to make ancillary to a substantive claim. So he's saying that rule applies even if the relevant order has a liberty to apply, which is obviously the case with the freezing order as continued under the continuation order. So even then, it is for the applicant or a variation to an interim order at the making of which it could have appeared, to establish and show on evidence that there has been a material change of circumstance. And that, we say, is what Prime has simply not done. It is simply alleged a desire to restart trading without any explanation, without any evidence, and in circumstances where both the claimant and the court are justified in having very significant distrust, given years of continuing contempt of both of the orders made, both the freezing injunction and the provision of information order. All of these points have been trailed in my skeleton. We are told that they're going to be answered by Mr. Page in oral submissions, but none of these were met in Prime's skeleton. The skeleton simply made a series of assertions, all of which we say fall down on any sort of scrutiny. So, for example, it said that the exception is an important safeguard. Well, that is, of course, true in the ordinary case where there is a history of ordinary and legitimate trading. The question, however, is begged in this circumstance: well, what is the ordinary course of Prime's business? As I say, it's not even clear to Prime itself. Prime needs an accountant in order to establish what is its ordinary and legitimate business, or alleges that it needs that assistance. Second, bald assertion: the claimant doesn't apply for a proprietary injunction. Well, technically, it didn't apply for a proprietary injunction, but the reality is that now it has NBK's accounts. Now it has the strong evidence, we would say, of the involvement of Prime in the fraud, and indeed the legitimate trading relationship alleged to the defence is, we say, entirely implausible. And it's only now, with the benefit of that implausible defence and the NBK accounts, that we are in a position to properly suggest the constructive trust, and indeed to plead the constructive trust claim. It is now pleaded in the particulars of claim that actually that the monies that were transferred are held in trust for us. And the freezing order, we say, can therefore be viewed as a proprietary injunction in the circumstances that have emerged since it was made. Thirdly, it said that the claimant will not be prejudiced. Well, that again, we say, is simply wrong. There is a significant risk of dissipation if Prime is going to start the sort of trading with monies going hither and thither, as we've seen in the transactions disclosed on the NBK bank statements. A very significant risk that very large amounts of money, and we would say, if received pursuant to any claim in Dubai court proceedings, that those monies could be dissipated before any judgment is obtained and enforced by the claimant in the DIFC court proceedings. It said that Prime will be prejudiced. Well, to make good that submission, it would need to show that it has legitimate business plans, and it would need to evidence those business plans. As if, insofar as it has historic trading, we say much of that trading is deeply questionable. And then it's further said by Prime as one of its assertions that the claimant improperly omitted to draw the court's attention to these authorities that establish, in my submission, what are fairly basic propositions. It is clear in our submission that the exception is optional. It applies as a matter of the court's discretion. It is because it's optional, it's in square brackets. There is a practice if one departs from a standard form order in the DIFC that the departure is explained to the court. We say that practice does not apply in the case of optional words that are included in square brackets. There is no gloss, we say, as a matter of English or DIFC law, that those square brackets, the optionality, if you like, applies only in the case of a proprietary injunction or only in the case of a post-judgment injunction. And indeed, I think the Milani friends appeared to accept that when he said that it reflected that that such a practice was reflected by the cases to which he referred, rather than there was any clear statement of principle to that effect. There is no authority, we say, for the proposition that is only in the case of a proprietary injunction or post-judgment injunction, as a rule, that a court may make a freezing injunction without making an ordinary course of business exception. It is a matter, as we say, for discretion for the judge, and we see, and indeed we note that there's no sustained suggestion that the freezer should be set aside. And if the Prime was confident in its argument that there had been a breach of the duty of full and frank disclosure, we do not think that Prime would have shrunk from making that application to have the freezing order set aside. But finally, it says that further safeguards could be added to protect the freezer. This is the notification order. These are used sometimes where it is felt that a freezing injunction would be too draconian, too heavy-handed. They require a significant degree of trust on the part of the court that notification will be given. They are very hard they cannot be policed by banks in the way that freezing injunctions are policed by the banks. And they are only, in my submission, helpful where there is a regular pattern of trading and where it's possible to investigate any trading in such a way as for any particular transaction or payment with a view to ascertaining whether it's properly made or whether it is within the scope of the ordinary course of business. And of course, what this would risk is all of the arguments one saw in Ablyazov about the scope of ordinary course of business, and one can anticipate that even with only 24 hours to get to court, the court would be bothered by a significant number of applications as to whether particular proposed transactions came within the ordinary course of business scope. In our submission, it is far simpler to say that in the special circumstances of this case, the ordinary business exception, in circumstances where the pleaded case, certified by statement of truth, is that business has been determined, the proper course is that the order should not be varied and that the absence of the exception should be maintained. My Lord, I have submissions on costs. Obviously, we would seek that costs be on the indemnity basis, given the extensive contempt, given the abusive explanation for that contempt that it was too late to comply with the court's order. We say these are cases firmly away from the norm, and the court should express and mark its disapproval of that conduct, as it has recently in a number of cases, including Basin Supply and Rouge, in dealing with abusive applications to the JJC with a view to delay trial. We say this is another case of abusive conduct, and the court's disapproval should be marked not only by a denial of the application, but also by an order for indemnity costs. And Lord, those are my submissions.
Thank you very much, Mr. Reid. Mr. Page, I think it's your turn to reply to the Mr. Reid assertion. I would beg you, please do not provide any repetition of your earlier submission, Mr. Page, if you just need to reply to that.
Well, yes, I won't do so. I'll make a couple of preliminary comments and then try to address as focused a way as possible Mr. Reid's submissions, which I think can be distilled fairly quickly. The preliminary comment I'd make is that Mr. Reid is inviting the court to take a seriously wrong and seriously dangerous step. He started off by making the assertion that I had not taken you to any authority suggest that interim orders that excluded freed injunctions were in some ways not optional. That is simply wrong, and is frankly a submission that should not have been made. The case of Halifax and Chandler, which I took your lordship to, paragraphs 18 through 20 squarely and irrefutably support my submissions that on the point of principle, the only appropriate result is that my client is granted the relief being sought. And given Mr. Reid's frankly wrong comments on that, I think it's right that I just read out exactly what it is that is said in the Halifax decision. In cases of what may be called ordinary business expenses, the court does not usually consider whether the business venture is reasonable, or indeed whether particular business expenses are reasonable, nor does it balance the defendant's case that he should be permitted to spend such monies against the strength of the defendant. Against
what usually
consider? Does not usually consider.
What are you reading? Sorry, again.
I'm reading paragraph 18.
Oh no, the page that.
Excuse me. I'm looking at page 15 of the authorities bundle. Mr. Reid will perhaps re-find his mute button in the meantime.
Yeah, 15, paragraph 18.
Yes.
Yes.
Page 15 of the authorities bundle.
Yeah.
Paragraph 18, which starts in cases of.
Yes.
So we see that in cases of what may be called.
Mm-hmm.
Then the second sentence, the court doesn't balance the defendant's case that about permitting to be spent money against the strength of the claimant's case. You don't have a sliding scale of let's look at what the allegations are, let's look at the strength of those allegations, let's look at the quality of the defence, and on that basis make a decision about the permissibility of individual payments and whether or not they're in accordance with the proper and ordinary course of business. The court does not indeed take into consideration the fact that any money spent by defendants will not be available to the claimant if it obtains judgment, i.e. the fact of dissipation is irrelevant on the point of principle. As I see it, that is because the purpose of a freeze injunction is not to interfere with the defendant's ordinary business or his ordinary way of life. In the fourth edition of Mariva Injunctions of Anton Pillar Relief, G says at page 318 the following: the court will always be concerned to ensure that a Mariva injunction does not operate oppressively and that a defendant will not be hampered in his ordinary business dealings any more than is absolutely necessary to protect the plaintiff from the risk of improper dissipation of assets. Since the plaintiff is not in the position of a secured creditor and has no proprietary claim to the assets subject to the injunction, there can be no objection in principle to the defendant's dealing in the ordinary way with his business and with his other creditors, even if the effect of such dealings is to render the injunction of no practical value. In my judgment, paragraph 20, the relevant principles are correctly stated in that passage. So, my lord, what you see there in that passage is squarely the statement that in all cases, and we're talking here in a context of pre-judgment freezing orders, there must be the inclusion of the business expenses exception. No ifs, no buts, no exceptions. The question only is whether a particular item of expenditure falls within the proper and ordinary course of business. Now, the court grants the order with the exception, always knowing that it is very difficult to police the exception. But there is only so far that the court can go. And this is a balance that has been struck going back now 40 plus years of common law jurisdiction on the point. It's clearly the claimant's case that any expenditure by my client would be otherwise than in the proper and ordinary course of business. Well, if that's the case, then upon us making any notification to them whatsoever, they will object and we'll have to come back to the court. But we say that's wrong. That's not the case. And we're perfectly prepared to have that argument. But it should be an argument on detail on the facts, whereas this application is about the point of principle. And the point of principle about should we be permitted to spend or deal with assets in the proper and ordinary course of business. And indeed, the submission made by Mr. Reid, the wrong submission, that I hadn't shown you the authority that makes good my core proposition in this application, I'm afraid simply masks the complete absence of authority that Mr. Reid relies upon to suggest that the exception is in some way optional. There is no authority to suggest that. There is no precedent within the DIFC court of the exclusion of the proper and ordinary business expenses exception from a freezing order that is made pre-judgment. And there is no precedent in the past 20 years from such an order being made in English proceedings. If the court makes a ruling now that says that the exception is, in cases of fraud, entirely optional and indeed so unremarkable that it doesn't even require the applicant to draw the court's attention to whether or not the exception is in the order or not, that would be a wrong and dangerous move for this court to take. It would be completely contrary to the surrounding common law jurisdictions, and it would be a serious misstep. I therefore invite the court to reject absolutely Mr. Reid's submissions to the contrary on the point. Now, Mr. Reid goes on to make I'm going to the end of his argument here, and I'll come back to some detail in the middle. Because the other legal point he makes is to rely on the Vanin case about orders and the appropriate time that should happen and the circumstances in which that should happen. Now, the Vanin decision is, of course, entirely right as a matter of general principle, but the proposition doesn't assist SPM at all here, because Prime was not present at the August 2018 hearing. It did not know about the August 2018 hearing. It would be a completely different situation if Prime had attended the return date application, indeed had attended and had opposed any part of the freezing order. We didn't, because we didn't know about it. So it cannot be said fairly against us that it's now too late for us to raise any comments or objections about the order, because this, frankly, is the first time that we have done so.
But
and we could not have done so.
He said you could have attended.
Well, but my lord, he's simply wrong about that. The error stems in the first instance from SPM's failure to serve the order appropriately. They served the order on the wrong email address, and it is common ground between the parties that they served the order on premises that are not regularly attended by anyone from our client. we have been clear and unambiguous in our evidence that we were not alerted to the order by NBK. So simply, we didn't receive any notice of the hearing prior to 8th of August 2018. Therefore, having not heard about it, obviously we didn't attend. So to take that point against us is both unfair and wrong. The application should be resolved on the merits. The application should be resolved in our favour on the point of principle. Now, all of the other...
Excuse me, Mr. Page, if that is unfair and wrong, is that then subject of variation or appeal?
Well, it is a subject of variation, because we're not appealing the freezing order out of time. We are seeking to vary it as is a proper step. And indeed, it's one point that Mr. Reid doesn't say that it's an inappropriate step to make an application. He doesn't say it's to be a matter for appeal. It is right and proper that we make this application to vary. We would only go to the appeal stages in the event that we're unsuccessful in this application. But the appropriate forum for us to make this application now is before you, my lord, who was the original judge who made the freezing order, and no one suggests other than that you have jurisdiction to grant us the order that is being sought by my client. And given that every other point has been taken before you, you can be quite confident that if that was a point that SBM entertained at all, it would have been led front and centre by Mr. Reid. So the points taken against us are all conduct points. Now, the irrelevance of those points is made clear in the passage I've just taken you to, paragraph 18, that we do not have a sliding scale here about whether the exception should be in or out according to the strength of the case or surrounding facts of the parties. We have to remember that nothing has been proved against my client at all. There is a lot of loose language being used in this hearing about alleged misconduct. All of it is inappropriate because there has been no application for committal. Freezing orders are very serious because they carry with them applications for contempt of court. Threats to make committal proceedings, to start committal proceedings, date back to about October, November of 2019 in Denton's correspondence. They have never been followed through. The court can conclude only that they are not being seriously made. And regardless of the seriousness of them in the mouth of the maker, no weight can be given to the point in the absence of such an application. And even if there was such an application, it would not impact on the relevance of whether or not to grant this particular application. This application is about a different issue. This application is about should we be able, or should we have the ordinary and proper course of our business interfered with absolutely by the order, or should this order be imposed on us subject to an ability to maintain a proper and ordinary course of business? We say that the proper and appropriate route in all common law jurisdictions to which DIFC should firmly align itself is with the latter option, and that this exception should be there and should be a front and centre safeguard for respondents to such applications. So that's what I say about, which then deals with many of the details of Mr. Reid's submissions about alleged toing and froings post freezing order.
Well, Mr. Page, I mean, it's very central to your argument. So the court got no discretion. I mean, the ordinary of business expenditure is mandatory, and that is the defendant's right anyway, and it should be having relevant of the party's conduct or past conduct or whatsoever. Then what I'm asking myself, then what's the point of having an injunction in a place? If there is an injunction in a place, and then if the party would be giving the right to have its expensive according to its ordinary course of business, and this would jeopardize that at least the assets under the freezing injunction. I'll go back and ask, what's the point of the claimant
So, my lord,
invest? Yeah, what is the simple answer to that?
It's a valid question, and the brutal answer is that there is only so much that freezing orders can ever do, and all the lawyers on this call will have at times past obtained freezing orders, and the Renish may be one example of this. We obtain a freezing order against a party that ultimately proves to be too late in time and doesn't give you a paper judgment, but doesn't give you commercial satisfaction. The answer about what does the freezing order do is it places on a defendant penal consequences for misconduct and immediate penal consequences for misconduct that do not depend upon prior outcome of the litigation and the company going to liquidation and the liquidator being appointed, and at that point, only at that point, seeking to unravel the transactions in questions. So it does bring conduct front and centre. What freezing orders also do is it imposes on respondents a level of transparency in their dealings going forward because of the notification requirements. Now, that is not absolute, and that may well and often is open for subsequent argument and debate. But nonetheless, that is the line that the court has drawn going back 20, 30, 40 years as to what the appropriate fair resolution is. Now, it would have been open, and of course it was open, and it still is open to the DISC court to take its own path on this. But all other common law jurisdictions have decided that actually the business expenses exception should be put in place because it, particularly for interim orders, because it has to be remembered that nothing has been proved against us. This all may well come to naught, and indeed we say it will come to naught come February of next year. So the court has to balance risk of dissipation with the fact that it has only heard part of the story, and it hasn't yet come to any final view about who is in the right and who is in the wrong.
I think, Mr. Page, according to your submission, the court could not balance anything because the court got no discretion with this ordinary course of business expenditure.
Well, my lord, that is exactly the point that Halifax and Chandra is making. That the question of principle
the discretion
exception does not depend on the court's sense as to the underlying merits. That they are two different and distinct considerations. It is a separate question about individual expenditure, and that debate we can and will have in due course with Dentons, but we can't get there because obviously it is not open to SBM to Prime to have any commercial dealings with anyone at the moment. So it needs to first of all obtain the relief being sought today that it is in principle entitled to continue some level of trading, and then having had that in principle permission, it can then go off and at the point that contracts are to be signed, assets are to be dealt with, earnings are to be made, money to be spent, it then gives prior notification to SPM. That is it is an imperfect solution, but it's an imperfect solution that is applied universally. If a different solution is to be found, it should not be found in the confines of this application, this hearing, and this litigation. It's a proper matter to be resolved by the Rules Committee and indeed by legislation if appropriate. The law in this area is so well established that it should not be tampered with, particularly in this light and somewhat frivolous manner, as SBM has done, without even being clear about why and how and when and for the reasons for which it did so. So just coming back to the very briefly, so I'm conscious of time, the point of detail made by Mr. Reid, there were in effect 4 points. So one is about merits. I've answered that, and we don't have this time scale. I'll give you the answer there. The second is about the asset disclosure. Well, the straightforward and the debate about whether or not we should have given it. It's a moot argument, and I don't really understand what is being said there, because we did give asset disclosure. It was given in June. Now, SBM would have liked it to be earlier. There was dialogue about agreeing a timetable for it to be given earlier, but that came to nothing. The defence was prioritised as soon as the summary judgment application was dealt with. So there was a natural and perfectly sensible internal order for these things. We've given the asset disclosure. As ever, there are questions arising in relation to it. There'll be further dialogue, which will doubtless continue through the case, but there's been no committed application arising from it. Thirdly, it's complained against us that the affidavit hasn't been sworn. Well, yes. I agree that the affidavit needs to be sworn, but that again does not impact on whether or not we are entitled, as a matter of principle, or indeed as a matter of judicial discretion, to be granted this application and the proper and ordinary course of business expenses exception. Now, the fourth point is that it said, well, this is now a proprietary claim because constructive trust has been pleaded out in the particulars of claim. That submission runs entirely contrary to the cardinal principles of freezing orders set out in the Abliazov case. If your lordship will remember, the three cardinal principles underlying freezing orders, the third of which is the strict construction point. It must be that any freezing order is interpreted and construed strictly, and that it is immediately apparent to the reader what the terms and conditions are. The fact that there is in a different document a proprietary claim is of complete irrelevance to whether or not there is a proprietary injunction. There has been no application to upgrade the freezing order into a proprietary injunction, and all comments as to what the merits of that may be, in any event, would still not engage with the point about, well, that would only attach to the particular assets in question over which a constructive trust is asserted. The answer could only ever be in respect of those assets, and would still permit proper and ordinary course of business expenditure for the non-prop injunction assets. So that submission, I say, doesn't help Mr. Reid at all. So, my lord, those are my submissions in reply. I hope I've addressed everything that Mr. Reid has said. I go back to the point I made at the start, but his submissions were made very fully and with a certain amount of gusto, but that should not mask their underlying weakness, and that this would be a seriously wrong and improper step for the court now to take, to suggest, as it is being invited to do so, that interim injunctions can include or exclude at will the proper and ordinary course of business exception.
My lord, if I could just pick up on one technical point, which said that there wasn't service on the Prime email account. If one takes up Mr. Jury's...
Mr. Reid, I would prefer if you deal with the other point, where he said it's not really up to the court discretion not to grant this ordinary expenses, with reference to the case at L15. If you have the reference, I'm going to give you the reference.
Well, he read out the relevant section, and I think I expressed some concern.
N15, paragraph 18 and 19.
So that's the Halifax decision.
The Halifax. If you want to comment on this, this is the only things I need really from you.
I just turned that up.
Yes, please.
Can you just give me the page reference again, if your lordship has it to hand?
L15.
L15.
Yes.
Yes, it starts, my lord. In cases of what may be called ordinary business expenses, the court does not usually consider whether the business venture is reasonable, or indeed whether particular business expenses are reasonable, and nor does it balance. Now, all of that we say is does not usually consider. What I was asking Mr. Page was for any suggestion in these English authorities that there is a rule that the ordinary business expenses exception can be removed only in the case of a post-judgment freezer. Now, I can't see anything in Paris 18, 19 and 20 which suggests that there is such a rule. I can see a suggestion that in England, it does not usually consider whether the business venture is reasonable. It doesn't usually balance the defendant's case that he should be permitted to spend such money. So I don't see that authority lays down any rule, still less that there is any textbook which purports to set out such a rule. If there were such a rule, one would expect to find it writ large in neon lights in the textbook, in volume 2 of the White Book, which explains the English principles and rules in respect of freezing injunctions, and indeed in G, the leading authority. I do say too that it's been suggested that all other common law jurisdictions have such a rule. Well, given that we've established that England doesn't have such a rule, it has, as a matter of what usually happens as a matter of practice, there has been no authority put by the court in respect of any other common law jurisdiction, still less in respect of all other common law jurisdictions. So, of course, we need to show special circumstances. I entirely accept that. I entirely accept that ordinarily there is a conduct of business exception, but there are very special circumstances in this case. Now, what Mr. Page is then constrained to do is to say, well, in the absence of a committal application, or in the absence of a final judgment, we cannot refer to any circumstances. And that prompted your lordship's observation that in those circumstances, how could your lordship balance anything? Now, the reality is that one can, if there's been contempt, and there clearly has been contempt. There was 8 months of contempt in this case, justified only by the suggestion that it was too late to comply, alternatively by the suggestion that we should have in some way engaged with D3 solicitors in seeking to negotiate the terms in which it complied. We were entitled to rely on the provisions of the order. We were entitled to comply. There was 8 months of contempt. Of course, we could have made an application to commit. Your lordship will be very familiar with the difficulties of committal in the DIFC. That's to say that the criminal authorities in the DIFC are the Dubai courts, and therefore there's no ability to commit to imprisonment a respondent or who has committed contempt of court. All one can do is either get a fine. This defendant is extremely unlikely to pay, or one can make a reference to the Attorney General of Dubai, and that reference procedure is entirely untested in the. I understand an application was made to Justice Shamlan today for such a committal, although it may have settled. So in those circumstances, to expect a party to make a committal application for the defendant to be committed for reference to the Attorney General before any reference could be made in respect of an exercise of discretion by the court to clear contempt over many months, both on the freezing order and on the provision of information order. We say those are strong circumstances. They are special circumstances which take this case out of what is described as the usual practice, or what the court usually considers as suggested in paragraph 18 of the Halifax judgment. Of course, this isn't a matter of appeal, because where one has got interim decisions that take place that affect the administration of the management of the case, circumstances can change. But that is what is required for the court in order to review a decision that is taken, so we don't end up relitigating interim applications even after a return date. I do wish to just deal with that point of principle, if I may, just so that that there isn't an error.
Very quickly, please.
Yes, it suggested that service wasn't affected on the Prime email account. If I could take you very quickly to Mr. Jowry's second statement, which is in the V bundle.
Page number?
Page number J19. And if I could take your lordship to page J21. And if I could just look at paragraph 13, second sentence. The freezing order was also served by email to each of the defendants using the email addresses referred to in paragraph 24 of the freezing order, which in relation to Prime, I understand, contains a typographical error in the domain, but also to rpshippingprimeenergy.com. The correct email address for notices in the sale contract Renish and Prime dated the 16th of April 2018. So it said that the order contained a typo, but my understanding is that service was affected on the correct email address, as well as is conceded by Mr. Page on the registered office, the post of the PO box of the registered office. And just in terms of the control of that account, the reference for your lordship's note is the RRFI CMC in the CMC bundle, and it's paragraph 16 of that, where it is accepted, admitted by Prime, owned and controlled. Perhaps it's worth quickly turning that up in the CMC bundle, in the RRFI. So one has those at I-24, and then if one scrolls down to RFI request number 16, please state whether Prime had control over and the ability to access emails sent to and from rpshipping@primeenergyme.com, and then one sees the response, number 16, yes, but neither Mr. Farhan nor Mr. Sarda exercised their control over this email address. So they say they didn't look at it, but they did control it and they did have access to it. And in those circumstances, we say for them then to say, well, they haven't really been served, makes little sense as a matter of procedure.
So you're saying they could have appear on the return date, they could have made the change they wish, they could have applied the court, they just did not.
My lord, that's the point, shortly stated.
Well,
My lord, I'm grateful for the time you've given us today. And
yeah, I do. I really thank you for your extensive time even allocated to present this case. You presented it in a very clear and good way. I'm very satisfied about the submission. It's just my turn now to reserve. I think I can decide the first two matters easily and quickly, which is the immediate judgment and the case management things. I would need a bit longer, slightly longer time to decide the variation order. Well, I can indicate that. So the first 2 points can be decided early next week, Sunday or Monday. Maybe toward the end of the week for the variation.
My lord, we would all be very grateful if your lordship were able to give judgment as promptly as that.
Yes, hopefully. And yeah, for now, I thank you for everything, and I wish you a very good day ahead.
Well, thank you very much for your time today.
Thank you, Mr. Bates. Thank you, Mr. Reed. Thanks.